if you have to give specific definition, UGC Act as well as I'm finding it on by way of the compilation of the statutes. The UGC regulation also defines affiliation, word affiliation. So I have just one page additional. We'll just have.
You passed on that?
I'm just.
Anyway,
so you pass on to your colleague first.
Yes, I've said I've.
16?
16.
9 UGC regulation defines affiliation.
UGC regulation
Defines.
It defines.
When I searched further, it came out from the Act also.
So you give that paper to the court.
Yes.
So that's what file.
I also have discussed with my learned friend on the other side yesterday evening. They had conveyed to him that this is the definition which is appearing. I have also shared with the memo with him.
Right.
No, we could have completed that, but perhaps he was a little bit reluctant. Lordship suggested that will submit his, record his submissions, but will dispose of that. No, regulating, withdrawing the, affiliation. So that was our intention also. It would have been.
But regulatory powers lie with the university.
Yes.
Yeah,
that's why I mentioned section 19 because this definition refers to privileges.
Privileges.
Yes.
Affiliation is also one of the privileges.
And
in accordance with section.
And perhaps your argument should have been that since the government notification or the notification by the cabinet conferred the power on the university as far as this affiliation is concerned, they being creatures of that notification cannot override that.
Correct.
Yes.
That's the fundamental.
In fact, now
what they have done,
they should have acted
there can be a notification taking up by the government taking away this affiliation, which you could have challenged. That's legality of that. But notification taking away the affiliation or making it temporary by the government and making Madhusudan Law University to be taking up fresh affiliation application.
But that is not the case.
That is not the case also.
The UGC Act itself says there is a definition of permanent affiliation in the UGC Act regulation which I have already filed. It's on record. Section 5.
That earlier memo you have enclosed.
Yes.
Okay. This is on record.
Since I came in the UGC Act, I have given that extra 12 days.
So we have the part. Toolkit, which American judges call. The lawyers have to bring the toolkit. Suppose if there is a vehicle problem, the mechanic will carry the toolkit.
Yes,
similarly, statutes you have to bring.
Yes.
Rulings you have to bring. Acts, etc. you have to bring. If there are our court ruling, because this is my court now.
Minors.
Very well. If there are no rulings of our court, other courts' rulings can be cited. Is it not? That is the way other public time is wasted.
Yes, ma'am.
That's the reason.
Yes,
okay?
Yes, ma'am.
Thank you. Please.
Item number 1 of today's list. Which is sought to be withdrawn today.
You want to withdraw?
Well, the judicial petitioner had filed another writ appeal, which he also wants to withdraw.
Which is that writ appeal?
Well, I'm giving that writ.
It is not posted today.
No, not posted, but arising out of the common judgment.
Very well.
That is as per your lordship's convenience, they call it and withdraw it. That is the memo filed by me.
Yes. By special notice, you
by special
notice.
You list it. Okay? Today, along with this, we can withdraw.
In item number 1, and there
you are there. In the new one,
yes.
You have to tell your friend to be here. You tell him.
Yes, ma'am.
We don't know what has happened. He may object to withdrawal.
Yes, well, I'm the
2 p.m. or as soon?
I'm the applicant over there.
2 p.m. Party 2 p.m.
Hearing in that matter for the respondent.
Yes.
Any objections?
No objection. No, I'm asking you.
No objection.
No. We will make an order.
Subject to withdraw with liberty for the appropriate forum.
Appropriate forum. Who are you?
I'm the petitioner.
You are for the petitioner.
Yes, sir.
Provided it is available.
That's subject to law. Subject to law. Petitioner, learned counsel for the appellant, has moved a memo seeking leave of the appeal. First off, he also tells us that in respect of the very same impugned order, there is writ appeal number.
Today it is
Number
78. 78 of 2020.
So 28, which also
So the council are different.
council are different. Correct.
He's departing, he's not.
Very good. Which also is
But I have mentioned number fact X.
very good. Next paragraph. Learned advocates representing the respective opposite parties in these appeals sent for the withdrawal, subject to the rider that if at all liberty is reserved to re-agitate on the same cause of action, comma, it has to be on a legal normative basis. First off, with this counsel for the appellant is agreeable. First, next paragraph. Right to institute a proceeding incidentally includes right to withdraw the same subject to regulation by law, said the Honorable Supreme Court in a curtain of decisions. First off, it is a right of the dominant treaties. First off, next paragraph. In the above circumstances, both these writ appeals are disposed of as having been withdrawn with the liberty to re-agitate in accordance with law. First off, in that connection, contentions of both the sides are kept open. No parts.
Though the matter is not in the list today, being mentioned by the learned counsel for the appellate is taken up along with writ appeal number 19 of 2024, which is in the list.
With the
Marked has to be mentioned
with the consent.
with consent of the parties.
Why pardoning? Have you committed any offense?
No, my
It's your right to mention. Mention it.
2023 read of it, by the state. When a single bill is allowed the matrimony.
So you want that matter to be heard?
Lordship.
We'll post it next week. Have you served a copy of the memo on the other side?
So
You should tell them also because he will be knowing his business.
I'm just taking a Xerox copy and post it.
Very well. Just serve a copy or tell him. All right. Have it week after next.
Writ appeal number 2569 of 24, my lord.
22.
24, my
24.
24. And I am the responsible of the man. I am a retired person.
You want to be?
Yes, ma'am.
Go give it that.
Okay.
Give.
If I am submitting judgment also, I am finding his lordship wanted and submitting.
Mercy, so and so,
My
date of Himachal Pradesh.
Yes, my learned friend.
Yeah, give that. Okay. Supply that after telling your friend.
Yes, yes.
Okay.
I'll do that.
Yes, brother?
Matrimonial appeal.
I
am for the
this year. Yeah. Next. Let us see. 6. 2012 company appeal. In this more than a decade old appeal, the arguing counsel are absent. First.
This matter again. She argued this, but somehow left. Maybe I don't know.
Great. What should we call it?
Can you locate Ms. Modi? I can see Mr. list or what? She is there. It is your matter. Six.
6 you have to read, no?
Yes. Respond.
Study list also, along with case papers. Yes.
I'm for the opposite party.
Opposite party. Are you ready in the matter?
I don't have any instruction in all the three matters.
No
6, 7,
instruction.
8. 6, 7, and 8.
Ah.
I'm for the opposite party, and I don't have any instruction from them.
No, you have to secure instruction. A lawyer cannot say, I don't have instruction. You should make efforts to seek instruction. Then you can make this submission. What instruction? It is an appeal. Appeal is on the matter of record, not for cross-examination of anyone. So that ground is not available now at this length of time.
The appellant's lawyer is also not there.
That we look into.
Appellant DP Math was the senior advocate. In the meantime, he has passed away.
Passed out or passed away?
Passed away.
His son is
Son is there, PK Math, he is in parent.
Okay. Then we'll issue court notice to the appellant. The court notice has to be issued.
His son is coming regularly.
His son is good. He's in panel also, in our panel also.
So you
We can inform in course of the
tomorrow can be stated, yeah.
Is it? But Supreme Court says,
Yes, we can.
where party is, counsel is dead, but
6, 7, 8 गोटे order करी. One order. Appellant now. Respondent S. Modi. MS.S. Modi. The matter has been listed in the heading of old matters and pending since last 13 years. None appears for the appellant when the matter is called. Mr. P.K. Mohanty, who is the advocate on record for the appellant, is a panel counsel for the state government.
Yes,
For the state government, the learned AGA is requested to inform Mr. P.K. Mohanty.
I'll inform.
The copy of the order shall be provided to the learned AGA, and the registry shall also provide a copy to the learned counsel, Mr. P.K. Mohanty. This day after. Wednesday or
whichever day. One day, because very old matters. I'm told more than 20-year-old matters are pending here. We'll fit
after
at least twice.
same heading.
Five matters. Yes, old matters will have at the top. We'll give preference to them. Otherwise, they will be in the queue permanently.
At the bottom.
Bottom.
Next day after in another same day.
okay.
Item 9. Both the traces after an instruction also. Whether anything survives, most likely nothing survives.
After this night.
If there is no interim order, then what sort of a order we can adjudicate? I mean, what remains to be adjudicated?
Hello, this is a company appeal. The respondent filed a petition under section 433 of Company Act for a winding up. But during pendency of that petition, my lord, one annexure 1, the infused, that order was passed. This order was challenged in these appeals.
What is that order?
Here also.
That order. What is that order? Order passed under which section?
Kindly see that order, page 11.
It's 11.
Well, in the meanwhile, that is the order. No,
Annexure 1.
your lordship.
Annexure 1.
Your lordship. May I read, my lord? Third one. The opposite party is restrained from carrying
Anything interest for the property in
interest
question.
character. The opposite party is further restrained from selling of any machinery or stock without keeping the minimum stock of an amount, 1.6 something, and thereafter Access Bank and so, and they are directed to keep at least 1
1 crore 60 lakh, etc.
So, my my lord, in this connection, my lord, since this is the matter of 2012, what are the development when I have to obtain instruction in this matter?
Okay. When will you be able to do that? How much time will you need?
2 weeks.
2 weeks.
Please check whether the boopet is still pending.
You see,
I don't think.
There is no stay also
No.
for those proceedings.
See, there is no stay, but one undertaking was given. Your lordship may kindly say there is an order.
Anyway, we'll give you 2 weeks.
Your
Come with preparation. Inform your friend also. Opposite party is there?
opposite party. Yes.
Very good. 2 weeks granted on request of learned counsel appearing for the appellant. First off, she request of counsel appearing for the other side of the matter being posted accordingly. First off, call after 2 weeks.
One line can be added that they should indicate the name of the counsel.
Not indicated. Who is the counsel appearing for the other side?
No.
Senior advocate SK Padi.
SK Party.
Because you have filed receipt, it reads receipt showing service of extra copy of the present appeal on the learned counsel for the respondent filed. So whom did you serve? Or even not yourself?
Senior advocate Padi.
When is associate?
Party. Registry to reflect name of Mr. Padi as representing
In senior counsel.
then we cannot issue notice to him. We can issue notice only to the advocate on record, not to the senior advocates. So let court notice go to the, because we can't put, so next court says in Indra Jai Singh that we court cannot issue notice to the senior advocates. Issue court notice. Your
Initial, in the advocate for the respondent.
Name was not mentioned.
So you talk to
I'll talk.
you talk to the senior. So leave it there.
There is a short signature.
Last sentence is not necessary.
last sentence to be sure.
Item 10.
Company appeal 1 of 2013. Number is very attractive, but the counsel are upset.
Which for the Union of India?
Who appears for Union of India?
This is for the EPF organization. There are panel of lawyers.
Panel, okay.
Body now who is the hazy.
You appear?
Mr. Jena, Mr. Sasibhushan Jena, I think. SB Jena is Sasibhushan. Younger Jena was present.
He is the associate of Mr.
Buddy. Same
For the parties, call a day after, to enable them to come and argue.
Inform Mr. Bhatt. Or anyone appeal for EPF now. If you can appeal, so. If you can appeal, also you can obtain instructions. No, it is already, he's on record. The appeal, he's the advocate on record for the appellant. So we can't, change the counsel that way.
This is on item number 11. Appeal is challenging the orders passed by the learned courts below as well as the honorable single judge. One of the facts of this case is this. The doctor before your lordship suffered mental illness and was in the mental asylum for years. the minor child was given in custody of the mother, my grandmother and grands. After she came back, the father filed an application to take over the child.
After who came back? From where?
Mother came.
Father was in asylum.
Asylum. Because the child was extremely small, he was kept in
Grandparents means maternal or paternal?
maternal.
Maternal. Wife.
First. As a prelude, it needs to be stated that for the grandparents to take the custody of the child arose because of the alleged mental illness of their daughter, as she then was. First, we are told at the bar, in all fairness, by Mr. Bose, that the mother of the child, having left the asylum in the right mind, had joined the and thereafter her husband moved an application seeking custody of the child from his in-laws. First, next paragraph. When we asked the learned counsel appearing for the appellant as to what right the grandparents can have over the child, in all fairness, he said, in the special circumstances, the normal rules do not apply. Therefore, the child that has been brought up by the parent, the grandparents all through, be continued on their lap. First off, this is a bit difficult to agree with. First off, the custody of child, the religions say, and the law enacts, ordinarily shall be with the parents, and more particularly the biological parents. First off, once mother of the child returned to the matrimonial home, her husband is more than justified in seeking the child to their home. First off, all child psychologists like Sigmund Freud and Carl Gustav Jung are of the opinion that the father of and mother of the child are very important for its mental and physical development. First off, next paragraph. In the above circumstances, we do not find any merit in this appeal, and accordingly, appeal is dismissed, reluctantly made easy. Yes.
Great.
Well, the humble submission I repeating for the respondent.
Yes, sir.
Due to bad health and due to rain, I am not able to present before the Honorable Court physically. So I
time?
Sir?
Do you want time?
I didn't understand.
Do you want accommodation?
So, okay, on Wednesday 25, sir, I will present before the court, Honorable Court. Yes.
They are the appellant, my lord, here.
Yes, I'm for the appellant, sir.
My name does not appear in the.
We tell the registry to show registry to print the name of learned counsel in the court list. First off, when do you?
Sir, it is not audible. Due to network problem, I'm not able to hear your voice. So
Please hear now, Mr. Can you please hear us?
Yes, now I'm hearing you. Now, just now.
Lordship is asking you, when do you want? Your learned colleague is also present. You can see in the receipt.
Yes, sir. Yes, sir.
When do you want?
I want to Wednesday 25, Wednesday. I'll be in the court.
For this matter, on 25 June 2025, as requested by learned counsel appearing for the registry to print of himself be signed so as representing the respondents in the court list. Next. We see. Appellant. Okay. Yes, sir.
My lord, the appellant order of my lord, on a single judge, and such then, page 62. Petition and repetition challenge the order of my lord, premature retirement.
Compulsory retirement.
And main ground is, my lord,
What was the age? How many years of service he had in order to be compulsorily retired?
56 years, my
He
lord.
was 56.
56 years.
What is the ground on which he has been compulsorily retired?
Lord, so see the order, my lord, at page 46 of the petition.
So Malik, it is stigmatic order or it was a as a
Non-stigmatic.
not stigmatic,
Non-stigmatic.
Non-stigmatic, my lord.
Then how can it?
but we were written departmental proceedings also.
We have two department proceedings are pending, my lord. They are only initiated the proceeding, then the child say, they gave the reply, no inquiries are happened.
No, for compulsory.
They deny.
That's the question. For ordering compulsory retirement, which is the rule?
Rule is 71, my lord. Rule
Yep.
71 of the Orissa Service Code.
Orissa?
Service Code.
What is? Give that. When an employee, a civil servant can be ordered to be compulsorily retired, what are the circumstances? How courts have interpreted this provision?
Rule 71 of the Orissa Service Code.
Open the rule, see the rule, and then give the way.
Service Code, Rule 71. Page 1. Section of the page 2.
Pages may not match because the additions may be different. 130. See, it's the duty of the court officer to open the, you're all trained that way.
Yes.
You have to open the book, or turn the pages and give it to the judge. We don't read. The rule, sir?
Rule 71, my lord.
Retirement of government servant.
Yes, ma'am.
Kindly read.
71 first A.
A.
Except as authorized provided in the another clause
Other clause.
in other clauses of this rule, the date of compulsory retirement of government servant, except a ministerial servant who was in government service on 31st March 1939, or class 4 government servant, is the date on which he or she attends the age, subject to the condition that a review shall be conducted in respect of the government servant in the 55 years of age, in order to determine whether he or she should be allowed to remain in service up to the date of completion of the age of 58 years, or retire on completing the age of 55 years in public interest. Then provided manner, provided that
That is government servant himself applying for retirement. That come to your aid.
government servant himself applied. Also, one part is that the appropriate authority may also.
The last put 5 lines to answer.
That also.
The appropriate authority may also require any officer retire in.
How many years of service you have put in?
Well, I have completed more than 30 years of service, but the age was 56 years, ma'am.
No. The appropriate authority may also require any officer to retire in public interest any time after he has completed 30 years qualifying service, or attained the age of 50 years.
years.
50 years.
50 years, madam. 50
Why
years.
are you reading 55?
No, 50 years. Sorry.
50 years.
50
Any
years.
amendment?
No.
No. So after you attain the age of 50 years, or you have put in 30 years of qualifying service, there is unqualified power with the employer
Yes.
to send you home.
Yes.
They have done that. What is wrong with that?
Madam, who is speaking, madam?
How this rule is interpreted? How this rule is interpreted?
This rule is interpreted by the Honorable Single Judge, madam. There
No,
is-
not by this court. These rules are very old rules, no?
Yes, yes.
Service rules.
There is guideline.
Constitution.
So therefore, lot of literature might have developed on
This rule is final to prevent, a guideline is provided by government to fill up the gap of this rule, madam. That gap. Page, the circular, madam, page 49.
Page 49 of this,
49 of the writ
your
appeal.
paper book.
Paper book. Government has provided a guideline. And that guideline is a part of the rule. As per the Honorable Supreme Court order.
You are referring to the read petition or the appeal petition?
Madam,
Annexure 9.
Appeal memo,
This is the appeal memo.
appeal memo.
9 memo.
Both in repression is there,
I am
madam.
looking at the petitions.
49 appeal.
You got it, madam.
Yes, yes.
And this guideline is as
Which guideline will come to your rescue?
per guideline, madam. In
Yes.
paragraph, madam, I have stated so in paragraph 8 of the appeal memo.
No, we are asking you,
Yeah, madam.
in Annexure A9, which you have pressed into service now,
Yes, ma'am.
which paragraph comes to your aid?
Paragraph clause 17, clause 19B, clause 8, they have a clause 15 also, they have violated. And
Let us read one by one.
yes, ma'am.
Yes, which is the strongest point in your favor here? Who appears for the government?
No.
Who is your respondent? Who is your opponent?
Government, madam.
Government.
Government.
Yes, sir, this rule is a replica of the colonial era. The earlier rules were promulgated under the Government of India Act 1935, which is pre-constitution. It was a constitution itself. Okay. During that, the longevity was not that good. Now, because of medical science, the health lifestyle, etc., the people are living longer now. Is it not? The mortality rate was very, very high those days. But now it is not like that. Men are capable of holding the ship up to the age of 65 in Supreme Court. That is 62 in High Court. And in America and other countries, we cannot compare because their styles are standard different. But here, the longevity has achieved a great leap. How can you maintain such a rule now? People used to die early during good olden days. But now the longevity is achieved. Kindly see what is the, in Google, what is the longevity rate?
Now,
Present longevity rate. You can't have law unchanged. After Shreya Singhal versus Union of India, a rule that is obnoxious has to be struck down by the court. It is obnoxious because the rule was made under an enactment which was 90-year-old, 1935 Act. That rule is reprinted under proviso to rule Article 309 of the Constitution with no change. But rule has of what is happening in the society, otherwise it loses significance. It requires consideration. What is your age now? Your client says now. The age of retirement here, that only thing is only terminal benefits. The number of service to be added and terminal benefit. What is the reasoning of the judge?
No record was produced before the review committee. So nothing was to do. Review committee was blank. And that was my specific petition. That was not denied by the state government. There was no denial of the state government.
Yes, sir. That longevity achieved during the independence has not been adverted to, while construing subject rule that was promulgated under the provisions of the then Government of India Act 1935 and reprinted thereafter under the proviso to Article 309 of the Constitution of India. First of all, this aspect is not adverted to in the impugned judgment. First of all,
that was not my ground in the petition.
We have to do justice, whether you argue or not. Can we deny justice to a litigant on the ground that performance of the lawyer is low? No. They come here. That was Oliver Wendell Holmes. In a very famous case, he said, our constitutions are meant for maintaining the practical rights of the citizens, not for jurisprudential theories. Okay. You are very fair. You are more than fair. We appreciate that. First of all, a case is made out for admission. First of all, admit. Issue notice. First, learned government advocate, AGA. Yes. So, on request, accepts notice for the respondents. First, petitioner to make over a set of papers to him immediately.
In our High Court pilot, it is already in the LMS survey. No
separate. Papers are with you now.
Yes, they are. They also find it difficult to download and print.
You give one set.
Yes, I will give.
One. That helps.
You are right.
Yes.
The rules have been changed for that.
I'll give
you, sir. Obviously.
Sir. Yes. The sentence will be there. But your lordship dictated one set of report to be sought on Mr. Anthi.
Just look into one judgment. Shreya Singhal versus Union of India. Singhal. Justice Nariman's judgment, where they have said even a statute can be struck down if it is manifestly arbitrary. Number one. Number two, because you are not challenged the rule. Even without challenging the rule, court can set aside a rule. Write down. Write down the judgment. You may not know. B. R. Shetty. Write down that judgment. B. R. Shetty versus State Bank of India, Karnataka High Court judgment. Just look into. That was rendered last year.
When here two proceedings are there against them.
to proceeding. Let us see.
Integrity is
No, as my brother asked, whether those proceedings are made ground for making this order. That you have to answer.
Yes.
They are just pending. Whether pendency of proceeding per se is sufficient, that we have to look into. I just read the rule. Rule says doubt as to integrity. Not every doubt. Not every doubt. Doubt has got its own meaning. In Bhagavad Gita, there is a shloka. Samshayatma pranashyati. One who doubts will wither away. Doubting Thomas in Bible. That way. Okay?
Lack of contribution of relevant materials. Let him so place.
With this bit calling. You can't be
Actually, whether it is allegation or denied, he says his specific allegation is that there was no material before the review committee
to form opinion.
At the age of 55.
Because 30 years he has already served. All of 31 years he becomes useless. Our welfare state cannot say that. Colonial government could have said, we understand that.
On the department, that was an elephant carcass. And subsequently, it has never been intimated to the authority.
Let us
lapse of some
just
time,
look
it was
into.
found it out.
Very well. Now you look into, assist us on the next date of hearing. In the meanwhile, how this court has interpreted
Yes, ma'am.
the similar provision, just look into.
Yes.
All right?
Okay, I've got it.
All right.
About all this.
Okay.
What petitions are they have filed? No, date can be fixed. Ma'am.
Very well. But date will not say, we'll say week. Week after next.
Good.
Item 13.
We are challenging the order of the Honorable Single Judge on the ground that when there was a ban on appointment of DLR and NEBR, my lord,
During ban period,
appointment was made. After the ban period. And for that, we terminated the service. After
how many years?
After 6 years.
6 years.
After 6 years, we terminated the service. That was challenged.
How many years they had put in by that time?
6 years.
6 years they had put in.
6 years.
They worked well.
Okay.
Ban was for what period?
And Lordship, see page capital B.
We are asking you the question. We will not see the page number.
Ban was, Lord?
Ban was for what period?
Prospective banning.
Complete.
That complete banning 12/4/1993. No
point. Judge has referred to Uma Devi.
Uma Devi says that irregular appointment can be regularized. And 10 years, there is a 10 years prescription.
That is not satisfied.
That is not satisfied.
Notice has to issue emergent notice returnable within 2 weeks. Then postal regular format is there. That will put that.
On condonation, Lordship issued notice.
And up to notice only we can condone
Yes,
delay.
yes.
Item 16.
Yes, sir. What is this?
Item 16, my lord. Here, my lord, pension. It's a work charge employee.
Child employee.
Given the full pension.
Full pension. Could not have been given.
Could not have been given.
Yesterday you read the particular rule, na?
Yes.
Which said the period has to be counted.
Lordship has kept the matter
On when we have kept it.
Yes, are you paying in pension or not?
minimum pension we are paying.
You mean say qualifying service 10 years, you have added and you have implemented
Yes,
that in the pension.
Yes.
But beyond that, you are saying that
The qualifying period could not have been longer than what is prescribed.
Yes. And moreover, we not
Anyway, so that those
first
cases are posted on which date?
tomorrow.
Issue. Yeah, but then we'll call this matter tomorrow.
Tomorrow.
Tomorrow. All tomorrow. Along it, do you read appeal numbers?
My lord.
Along with it appeal numbers went. So
We'll provide Kaliro Channam right over.
you give it off.
Words.
item 17.
This is regarding same matter. Same matter. Identical.
All benefits in favor of the petitioner. Tomorrow.
Identical matter.
Yes. In the meanwhile, serve a copy on the advocates who represented the employees before the learned single judge. Whether such a rule is proceeding rules?
Yes, yes. We will in course of
But they may refuse.
They may refuse, of course.
But you try to stop them.
In course we'll make an effort.
Tell them and ask them to be here tomorrow.
Yes, we'll make an effort. It will not.
Yes.
The block grant employee has been given the benefit of the aided institution. The regular institution. Then the Orissa Aided Educational Institution Employee Retirement Benefit Rules 1981 application of such rules stated the aided non-government educational institution has been enshrined under Rule 3. The concerned rule we have placed before the Learned Single Judge, which are not taken into consideration.
What the rule says?
Rule says, I am reading. Nothing has been.
But there is one judgment of this court, Satapati, the Anup Kumar Senapati.
Sharat Chandra Parida was confirmed by Anup Senapati also.
The batch of matter is there, my Lord Justice Sahoo dealing with that along with Justice that is block grant pencil.
Many matters are pending.
Many matters are pending.
Give full list of the matters. One day we will put an end to all this. This way or that way.
Yes,
You can't go on keeping like this issue. Emergent notice.
Lead matter is there. WA 197 up to 2024.
Give full list of the matters. One entire list of the matters, so that by one stroke of pen we can decide all these matters. All this matter issue.
Mr. Maharashtra also check in your office.
Other matters.
Because you are the appellants. So you, the dominants.
We will check up and provide the list to the.
By one common judgment.
Sharat Parida, Anup Senapati.
Yes.
That way you can find out.
Yes. All this matter. Issue emergent notice. Call this matter.
That matter is being addressed by Learned Advocate General.
All right, no problem. That we most welcome.
And 2 weeks.
Notice you should have to take notice in this matter.
In this manner.
Yes.
Call this matter after 2 weeks, along with list of the cases which learned additional AGA would furnish. One of such matters being writ appeal number
197 by 2021.
In that matter,
write down and you.
In that matter, what happened? 2 months back, Learned Advocate General has taken time that the matter shall be solved.
So whatever may be the
Let us.
read that you are saying.
WA 197 of 2024.
197.
I have just mentioned. 197 of 2024.
Please remind the Advocate General also that he has said like this. All right.
Well.
Quote on almost identical issue. That matter went from Tamil Nadu. Medical issue. I don't remember name of the part. Very quick with me nowadays. So that's a matter that went from Tamil Nadu. Just look into it. It appears it has been decided in favor of the employee. Yes, sir.
By passing the order, by single judge, consider
7B2 of the Odisha Education Act 1969.
What does the rules, that section says?
Section says below.
Give. Record facts.
7B.
Education Act.
Married.
Yes.
7B2. 7B2. If an educational institution shall appoint qualified teachers and non-teaching staff by making selection in accordance with procedure and criteria prescribed by the state law.
Mr. Pratap, you are reading Odisha Education Act?
Yes, ma'am.
Section 7.
7 Act, Section 7B2.
7B2.
Yes, ma'am.
Whether prescribed means prescribed by rules.
Yes, ma'am. Prescribed
Whether
by the
rules-
Act and prescribed rules.
Rules.
Rules and government instances.
No, prescribed is prescribed by rules. So, page 137. 137. 137.
We have got 136. 136. 136.
137.
136.
State government. 7-2.
7B2.
B2.
Yes, ma'am.
7 capital B2. Every nation shall appoint qualified teacher and teacher by making selection in accordance with the procedure and criteria prescribed by the state government.
Yes.
Criteria for
Apart from that, rule.
In the petition, you relied on 7B2.
Yes, ma'am.
Which paragraph? Your rights emanate from 7B2. So, because or else how the court will look at it on this?
unless you had argued.
Para 1.
Read.
The appellants Brahmachandra has filed
No,
the
it's petition, sir.
read the
Because
appeal.
the single judge.
I was not the petitioner. I was the opposition.
But all right. But did you press into service this provision?
Yes. That was placed in the order of the Lawrence Singh.
That was placed also. Whether it is referred to in the learned single judge's order.
Yes, that is referred.
Referred also.
So, Baman Charan Mahanti was the
Opposite
Petition. He has
was
succeeded.
petitioner.
petitioner managing committee of this. I was
Managing committee removed him. Or was
Yes,
prohibited me to function as a teacher.
Yes, then I approached for the director.
So
Director passed order in my favor.
that was challenged by
By the managing committee for the Lawrence single judge.
So before the director as well as before this, the honorable single judge, you said that 7B2 comes to your rescue.
Yes.
What is the finding of the director on that?
Director
Or the single judge in judgment which you are impugning?
Yes, Your Lordship. Your Lordship may come to the page 47 of the my writ appeal. That is the judgment of the Lawrence single judge. Page 47, operative question. Para 8. 7 at para 8.
Just give us a moment. Paragraph 8.
page 47, paragraph 8.
We are getting there.
Yes. Having
had the learned counsel for the parties and after going through the materials available record, this court finds that opposite party number 4.
last 7 lines.
Last 7 lines.
This court, after going through the provisions contained in section 7B2 of the Act, is also of the view that with regard to appointments, the employees in aided education, unaided education, government is required to follow What was your age?
My age was at the age of at the time of appointment, my age was 41.
Then how? The law prescribes 32.
No.
Huh?
So far the private education, so far the age of appointment.
Even after 75, one can be appointed.
No, that is at the age of, at the private, so far the Education Act and rule is concerned, there is no maximum age limit.
Therefore, any time you can be appointed.
That is depend upon the managing committee, Millard. There is no specific age.
Did you challenge the earlier order passed in WPC? Just look at paragraph 8 again. Read it from the beginning.
Yes. Having heard the learned counsel for the parties and after going through the materials available record, this court finds that opposite party number 4 challenging the action of the managing committee in not allowing him to discharge his duty with effect from 16th March 2007 moved opposite party number 2 by preferring an appeal. pursuant the order passed by this court in WPC number, opposite pattern took the appeal, even though it is the case of managing committee that by the time opposite pattern was appointed by the education agency, he had crossed the upper age limit of 32 years of the opposite pattern. Since at that time of his appointment age was 31 years. His date of birth being the 15th February 1972, opposite pattern number 2, by deciding the appeal has not taken the stand of the managing committee in its proper perspective. This court, after going through the provisions contained under section 7B2 of the Act, is also of the view that with regard to appointment of the employees in unaided education institution, the institution issued by the government is required to be followed as per the government instruction, the maximum age limit for sustenance of appointment 32.
Which is that?
For a movement, your lordship,
No, kindly complete 8.1 also.
8.1. In view of the nature of order passed by the director, it is apparent the opposite partner was overaged by the time of he was appointed, and the managing committee has been directed to condone the overage. It is the view of this court that there is no provision either under the Act or under the rules giving power to the managing committee.
Asked by my esteemed senior. That was the question asked to you, that which provision,
Yes,
which provision
yes.
or can be condoned. You see, first of all, there is an upper age limit.
Yes.
You are saying there is no upper age limit.
Yes. So for the private education,
The second part is that, yes, you in fact, you kept quiet when you were asked at 75 years or 60 years or 58 years. What could be? I mean, 59 years, 11 months, 29 days. According to you, I mean,
But just
theoretically.
exploring.
Theoretically.
It's a process of reasoning.
Process of reasoning. So, what they are saying or discussing. So what is your answer to, in fact, already?
Well, let us see why you say that this norm is not applicable.
at the time of appointment,
Take us to that provision. Which are the rules?
yes, ma'am. Then your lordship first, then 7B2 is there. Then your lordship put 1990.
7B2 only says prescribed by the government.
Yes. Then your lordship may
Where is prescription?
yes. Your lordship may come to the Orissa Service Code Rule 52.
Rule 52.
Orissa Service Code.
Orissa Service Code is applicable to this
So
also.
government have made guidelines instructions there. That has been dealt with by the Lawrence Single.
1 second. He is defined by the Supreme Court. When a statute says prescribed, do you have Orissa State General Process Act?
Yes. Also applicable.
Prescribed by rules.
52 of the Orissa Service. Judgment. Single judgment. Yes. What are you reading? 6.1. Yes, this is the Learned Counsel appearing for opposite.
When you are reading, you are going too fast actually, missing some words.
Take us with you.
Learned Counsel appearing for opposite pattern number 3 also contended and on Rule 2 of the Orissa Service Code, even though person whose age exceeds 32 years may not be admitted into government service, but in view of the notification issued by the self-same government on 21st March 1941 and 27th September 1949, the managing committee has got the power to condone the age. The contents of the notification dated 21/3/1941, 27/3/1949 are reproduced here under. Notification. What? Exemption from age specified for entry to
Kindly maintain silence in the court. We are on work. Don't disturb. Yes.
Exemption from the age limit specified for entry to government service. It has been decided by government that when in the appointing authority's opinion, a person appointed in a first instance in an officiating or temporary capacity is likely to be made permanent at a later date, the question of exemption from age limit, if necessary, should be considered and formal sanction to the exemption may be accorded at the time the person is confirmed in government service.
How many years of service you have put in?
I have appointed in 2013, Miller.
2013.
In 2000, at the age of 41, the managing committee appointed me. I have requisite qualification.
No, we're asking one question, one answer. You must confuse us. When you were appointed, you had crossed the concerned age limit, arguably.
Yeah.
You say there is no limit at all, we'll consider that. So you were appointed on which date?
That is on Miller. I think 16/3/2017. Mr. Sorry, Miller. 1st March 2013. 1st March 2013.
The selection process was undertaken.
Yes, ma'am.
You had produced your SSLC, HSC, HSC mass card.
Bachelor degree certificate, bachelor in education.
It contains your date of birth also.
72. Admitting.
Yes, at the time of management, I produced my matric certificate, that is board certificate, where my date of birth was there. After knowing all these things, the employer given me appointment on 1st March
2013.
Yes, ma'am.
Are there any complaints against you? In which subject you are?
His Bimela's was the science teacher.
Science teacher.
Arts teacher.
Arts teacher. Both art and science, everything you are teaching.
Yes.
So, a selection committee comprised of whom? Who were the members of the selection committee?
That is managing
It
committee.
comprises of whom?
That managing committee prepared a selection committee, and I placed the selection committee, and accordingly they given me.
Selection committee comprised of whom? Any member from government?
No, it is a purely private.
No, that's all right. There was no government nominee.
No,
Are there
nothing
any?
was there.
Who has power to make appointment under
The
the
managing committee, as per the provision.
committee, managing committee?
So, Pratap, this question has relevance because they themselves challenged such appointment and claimed by you.
No, that is not. They have prohibited me.
You make total prohibition or restriction or whatever way. You see, it is between you and the managing committee.
Yes, Miller.
You rely on their act.
Yes.
They challenge their own act. So you have to show that this managing committee which appointed is the same managing committee, because there is allegation that there was no proper managing committee. This managing committee says, the appointing authority itself says, it's a very peculiar case, that your appointment is contrary to rule. They themselves say, that's the difficulty here.
No, that was not the stand before the director.
No, who went before the director?
I went before.
Why you went before the director?
Because I was prohibited by the management to perform my duty.
Therefore, question is, to some extent, it's on the estoppel also. Having appointed you as a teacher and having extracted your blood and sweat for how many years?
4 years.
4 years.
Yes.
Can they now turn around and say, no, you are age barred and therefore we could not have appointed?
Yes.
That question arises. But there is no estoppel against law. That's also true. But that does not mean after retirement they could have said, you could not have been appointed, therefore we will withdraw everything. Many reflections elaborate.
So when they prohibited me, only in order
There is no prohibition at all.
No, I was prohibited by the management.
No, that's all. The age limit we are speaking of. You say there is no prescribed age limit for private educational institutions.
Yes. There is no age limit so far the private institutions.
No judgment on that point?
No, Miller.
Issue notice and let us see. Did you have an interim order in the court below?
No, it was before the director initially.
You had the interim order.
Director.
And what happened before the
Director allowed my appeal, director, the management take back me, and accordingly that order. August 2017.
Then we'll issue notice.
Already notice has already been issued.
Was engaged.
Already notice has been issued. The private management already appeared through his lawyer.
Private management is here now.
No, he's in the law.
All right, but you bring him. How can we decide this important matter? Tomorrow we may be blamed to lay down a wrong precedent.
The list in the Mr. Mohanty is appearing. Amiya
Mohanty.
Amiya Mohanty is appearing.
You have to
within the cause list.
That's all right. You have to offer him a cup of coffee and bring him here. Otherwise he won't come.
Will it come for admission?
Huh?
No, 15 days, 16 days.
Delay will continue. This intra-court appeal. This intra-court appeal is filed after booking a short delay of
16
days. 15 days. Perfect. An application supported by an affidavit accompanies the appeal seeking its condonation. First term, delay is short and explanation offered is plausible. No objections are filed to that.
No
objections are filed to the subject application. First term. Next. Application is allowed and delay is controlled. Let us see it. Move at least one stage further. We understand. Just see how courts have viewed. There are some judgments which Justice Ramajai quotes in his famous book, Services Under the State. If his board man is appointed, and can he be removed after long years? If he is to be removed, what are the consequences? What should be compensation? All these aspects will arise. Just look into Justice Ramajai's famous book, Services Under the State.
Next,
after 2 weeks, because we have posted many matters. After 1 week, you have waited for so many years. After 2 weeks, it will come.
Yes.
Okay. Call this matter on some date. Whichever date you want after 2 weeks, pull down from the calendar. 30th of
July.
It will not be 2 weeks. Arithmetic says it will not be 2 weeks.
30th of June.
Or something like that. Okay. 5th of June? July? Okay.
5th of July.
5th of July.
7th
on the heading.
It will come that way, don't worry. Yes. Take this. Yes, sir.
Notice from issued on the procedural limitation on 30th.
Delay is there.
Yes, delay of 23 days.
What is the matter, main matter? On merits, just a few words.
That is a matter relating to grant of promotion on the area advancement scheme.
CAS.
Yes, CAS.
That is given to you.
And for the
University. Relief to the.
Yes, ma'am.
What is wrong with the order of this?
The order is that Honorable Single Judge has directed to consider his case
The statute says otherwise, indicates otherwise.
Yes, that I know. What has happened in that 2014 notification, only applications were invited.
So, applications you had invited before approval.
Before approval.
Why did you invite the application?
Yes, with that condition, interview will be started after approval.
After the approval.
Yes.
Interview.
Yes. That's why.
Yeah.
So when did you start up the interview? Then now again the question comes back.
Because
After the approval.
in that
You interviewed after approval.
after approval.
After approval.
Yes.
So your conduct itself shows that
No,
you are seeking
now-
approval. No, please.
Sorry.
Either you know the question, then you can answer, or I have to complete my question.
Sorry, ma'am.
No, why should be sorry? No?
Yes.
Don't be apologetic. Argue with all your vigor, and because you yourself notified that there is no approval and we're waiting for approval, and so you also intended to show that You are awaiting approval, but still proceeded ahead. That was the query to me.
That was our intention.
And approval is accorded.
Approval is accorded.
Then you give effect to that one. How learned single judge are treated this?
That has not been treated.
That issue is treated.
So you
But generally CAS promotions, they stand not on par with regular promotion.
Yes, but
For regular patients, so many conditions, availability of vacancy, and ladder, all these things will arise. But in CAS, vacancy is not the factor.
no, one clarification was issued by the UGC. Those who are in the service role, are only eligible to get the CS. If you submit
That clarification is issued on which date?
that subsequently.
Then how that is going
No,
to
that
apply?
prior to 2014.
Prior to 2014.
If your lordship will contemplate, fix a date for.
You appear
I am
for
appearing, Lord. Ask your lordship, since my learned friend has said on merits, kindly see
I have not
paragraph
said on
1
merit.
second. Yeah. Kindly see paragraph 6 of the improved. Just kindly, sir. Paragraph 6 and 6.1.
page number?
Page number 5 of the judgment. Internal page 5 of the improved.
Page 44.
Having heard and counsel for the
Just a second, give us a moment.
Yes, I'm so sorry.
Having heard and
Yes, kindly continue.
Lord, having heard and counsel and now going through materials available record, this court finds that petitioner was promoted to the rank of associate professor by an order so 2006. Pursuant to the circular issued by the university in 7/12 to 2016 Annex 3, petitioner made his application to get benefit of promotion to the rank of professor stage 5. As found from the notification issued by University 19/8/2014 and Annex 2, petitioner by the time he made application, he was eligible to get the benefit of promotion to the rank of professor. But even though petitioner made his application within the stipulated time, the matter was not considered in terms of provision 6.3.1 of the guideline issued on so on. However, taking a plea that the petitioner has retired from service on 31st of March 2016 and facing reliance on letter issued by University 5/4/2018 on Annex 7, claim of the petitioner rejected. Kindly similar 18, not 49.
That's all right. But what about approval of the government?
But approval always belonged from the date of the when the process was initiated. Process unless otherwise directed. And that is
How the policy is evolved under which provision of law? This CASDC
like they have
evolved.
independent guidelines.
To show that under what provision of law?
That part of the record. Let him submit a copy on that.
I remember if your lordship pleases to run the delay of 28 days.
That will do,
Yes,
but you have to convince us of merits.
yes, that what I am submitting.
How can you act upon 5/4/2018 circular letter
No.
post retirement of the petitioner?
In High Court, we have rejected his representation.
5/4?
2018, my learned senior.
No, placing reliance on the letter issued by the university.
That's no, sorry, that what I said.
Not
That has
said.
been rejection of the.
Very well. Bring that famous judgment of the apex court,
Right.
which dealt with the CAS promotions.
I'll do that.
There are two judgments of the
I'll do
apex
that.
court.
I'll do that.
How the court should view
I'll do that.
the claim for CAS promotion. All right? We condone the delay.
One more aspect, Lord.
No, you bring everything.
But I'll bring everything. So far as the delay also I have my objection. Kindly see the
Application.
a single
Short
thing,
delay.
not Subba Reddy says, the decision judgment. Subba Reddy says that it's not a question of length of period.
But in your matters, last time we have condoned delay of more than 200 days.
In fact, it's not my mind.
You argued that matter.
I don't-
You argued that matter.
Yeah.
Before myself and Justice KRISHNA Mahapatra. You may not remember, I remember.
It's a very difficult to adjust for my lord's memory.
Anyway, delay. On delay, we cannot
But
deny.
I don't know. But if your lordship sees the application,
See, there is a scope for improvement even in heaven, said Oscar Wilde.
Lord,
There is a lot of scope for improvement in your pleadings.
may I suggest?
Ah.
May I suggest?
We'll condone delay, subject to condition that we will go one good book on law of condonation of delay. To the association library.
What I'm trying to suggest.
It's all right. Appeal is filed after booking a short delay of
28 days.
28 days. First term. Much older matters than this are languishing in the court cupboards. First term. An application supported by affidavit is moved seeking condonation of this delay. First term. Delay is too and explanation offered is plausible. First off, true it is that there is lot of scope for improving the said application as well as the affidavit, if not the appeal memo. First off, be that as it may. First off, condonation of delay would not add extra merits to the appeal, to the disadvantage of the other side. First off. Next paragraph. In the above circumstances, application is favored, delay is condoned. Next day, to bring it to judgment, how they have put the normative process as to how the court should view the cases of CAS. These are not regular promotions.
Yes.
They are CAS promotions, career advancement schemes. They are.
Things are given notionally,
That's what.
not even financial benefit directly. If you persist with the judgment,
Let us see.
Honorable Single Judge are directed to give it notionally.
Reported till 21 days.
21 days.
Reported till because they have just reported.
Whatever. Okay. I'll bring one is justice by Justice Markandaya Kaju, another is by Justice Dinesh Maheshwari. Okay, which means and youngsters can read them. They will throw a lot of jurisprudential light on the existing knowledge. Yes.
Fixing a date, man.
Which date you want? The date to fix after 2 weeks, the 3 weeks, in July, 3rd week. Short point.
Third week of July.
But you should not trouble the teachers. Teachers are very important. You may not know, there is one judgment in 2014 by the Apex Court, by Justice Kuldeep Singh versus Union of India, Justice Kuldeep Singh, and Justice this one. During World War I, World War II, from 1914 to 1919, World War I, 1939 to 1945, World War II. The salaries of judges and teachers were enhanced in England, but the salaries of all other classes of employees were downwardly revised. Okay, of course, during recent war, the salary of judges is not enhanced. It's another thing. Very good. Bring those things. All right. Next one.
Item 23.
In this matter, the Rehabilitation Assistance Rule 1990 was under challenge and they are seeking relief under that one. During pendency of the writ appeal, my lord, we have the government of Odisha has brought in a new statute overriding that 1990 rules, my lord. And the petitioner case is well covered in the new statute which had been brought into force, my lord. Rehabilitation, Lord, kindly have a glance.
You don't want to press the appeal? File a memo.
No, he's arguing the
Arguing, my lord,
On merits.
on merits, my lord, I'm suggesting, my lord, that the Honorable Single Judge order directing us to consider the case in the light of that earlier statute may not be
Correct.
appropriate.
Suppose if right to consideration arises under the repealed statute,
And that has been taken care of in the new statute.
which is that section?
That
Which section?
section 2, my lord.
2.
Yes.
After filing of the appeal.
After filing of the appeal, appeal is of 2004, my lord, and the statute is of 4th April 2025. Recent.
It is with retrospective effect.
Retrospective, my lord, the cases of originating from the source that
No, does it say, notwithstanding any judgment of any court?
No,
Does it say that?
When judgment have been
The judgment is it concretes the rights of the parties.
Therefore, my lord, we want that university may issue notice, then we'll hear.
You convince us. We'll issue notice, no problem. But you convince us.
He's present.
Unless the statute says, because that same aspect arose before the Apex Court in Indira Nehru Gandhi versus Rajanarayan, where the constitution, the amendment to the Representation of People Act said, notwithstanding any judgment, decree or order of any court in the country, whether such
To the election.
election petition that was not, they wanted to set aside Jagmohan Lal Government declaring Indira election as null and void.
Rules of the game can change after the game has begun.
That's
That is tender, but it is statute.
No,
you can't.
Rules of the game and after it is.
That is one thing. This is a overturning the judgment of the court.
No.
Whether unless there is that it is possible. You can overturn always. The power to legislate includes the power to set aside the judgment.
Another aspect is there. Another aspect is there.
If you agree with him. Milords. Now they have filed an application for condonation of delay that.
In fact, he is saying that this subsequent amendment brought in April 2025.
Milords.
Instead of earlier one
will be.
Your case will be considered under this.
Adhering to your benefit. That is the summation only. So you can examine and respond.
You do not know.
Let me examine.
No copy has been sought to be.
Give copy.
And also file it in the court.
Oh, my lord, I'll file with a memo.
Because it is subsequent to the.
Yes. I will file an affidavit.
Is it equally beneficial?
Yes, equally beneficial, my lord. And
then why do you challenge?
No, beneficial to the, my lord.
Correct. But why then where is the right to challenge? For filing appeal,
but
there should be grievance, cognizable grievance.
Judicial observation is required, my lord.
No, that's all right. What we are arguing.
Because
now,
in the earlier judgment which we are challenging, that has not been dealt with this aspect, my lord.
They could not have.
this rule itself has come now. Our judges are not sarvagnyas. We can't predict what you're going to do in future.
Let him examine and we'll.
All right, you take notice. We'll condone delay also. Short delay.
Delay of 237 days.
All right, it's all right. It's the state, na? State never acts so fast.
Please.
It always competes with the snail. Yes. And the snail, if I say that, snail may have defamation suit against me. Why are you comparing a state with me? I go faster.
I pay a copy of the read appeal.
Appeal is against
Yes, I'll provide.
against the judgment of learned single judge. Personal. It is filed after brooking a short delay of 200 odd days. Personal. An application supported by affidavit seeks its condemnation. Personal. Learned counsel appearing for the, on request appearing for the respondent employee opposes the application. Personal. There is one finer aspect which need to be adverted to. The government has come out with a new policy, wide notification dated 4th April 2025, which also provides for grant of relief of the kind which the learned judge has directed to grant. First, however, there are some aspects which need to be examined in greater detail. First, in the above circumstances, application is favored and delay is condoned. Subject to the condition, you have to give some good books to the library. Which book you will give? Give law and social.
Copy of the rate of payment can be sought.
Very well. Copy and coffee also. Give.
No.
Don't take
Give Korapur coffee. One cup.
See, Lordship, can you fix a date? After 3 weeks,
3 weeks. I'll fix something. Call on.
Okay. Again,
This roster also contains challenge to virus.
no. Single judge, may not.
He could not have.
The pure 12 persons.
At page 5 of ground number C, we have taken that ground.
Without there being a challenge
Yes.
to the statute. Yes, declared statute as well. How? What Ramakrishna Dalmia versus Justice Tendulkar says, unless challenged and unless that challenge is required to be reconsidered, Shirvai in his 4th edition has given 7 principles when a statute can be set at naught. And one of them is one ground which is now reasonable.
They appear under
Issue.
limitation.
Delays that?
Yes, there is delay. 170.
Government is known for filing appeals with delay,
No,
with varying number of days. How many days delay? 178 days. Tell good book, which good book you will give to the library. That's the only way.
I will engage my librarian on this aspect. Now, the Lordship may only quote that book we will bring.
Very good. Same order. 178 days. Subject to presenting Samaraditya Pal service law. By a set of books. Samaraditya Pal's service law. to the advocates library. Yeah? All these are to the advocates library. Okay.
My lord, we have prayed for stay of the.
The unimproved order needs to be stayed.
Lordship's picture that and my lawyer is directed to be sorted.
It's a,
In the meantime, some development, my lord, your office permission, I will make something.
no, we are asking you. We have been taught in the college. Shirwa is 4th edition.
No, but your lordship will condone the delay.
No, stay also.
Read. How can you say that you have not read Silvice 4th edition, not what you are saying? No, I think no, you are to the extent of telling that you have not read Silvice 4th edition.
The challenge,
Even the color has not changed, sir, because Silvice himself said that it will not be edited.
And he said he shall not be edited for 50 years.
50 years.
He was afraid. He thought that he was the last Mughal of constitutional law.
in the meantime, they have implemented.
Huh?
In the meantime, they have implemented.
Have you implemented?
Yes, my lord.
In the one hand,
They have
this Honorable Single Judge order has been implemented. In another way, filing a writ appeal challenging that order.
Then, my lord,
Then you fail out. Let them
substance.
That's what.
then you will see. Some matters are go to the before the divisional bench. In this case, same case, before the honorable single judge, and some cases go to the before the divisional bench.
Yeah.
The single bench first pass the judgment, my lord.
It could not have because
Your lordship party that care.
Just wait to respond to the question.
kindly see this. Brother,
Listen.
1996 Supreme Court, State of Rajasthan versus so and so. The apex court said, it is the prerogative of the Chief Justice to allot the roster, fix the roster. Where a particular matter is not within the roster allocated to a judge, if he passes an order, it is order without jurisdiction and ab initio wide. These are the words, maybe sentences may be little different. I'm telling it from my memory. It is in 96 Supreme Court. A judge of the court cannot decide a matter which is not allotted to him. If he decides one, it is an order ab initio wide. Number one. Number two, how the learned single judge address the validity virus of a statute, which is not the matter of pleadings. You cannot do it. The judges are not Mughals. We are bound by the constitutional limitations. Therefore, requires consideration.
Yes, man. What they have implemented. They have implemented.
Learned
This order of the honorable single judge
argues
also
that
in the divisional bench also.
argues that the learned single judge did not have roster jurisdiction.
Just
Number one. Secondly, the learned single judge could not have uttered even one single word about the virus of a statute or a statutory instrument in the absence of pleadings. Mr. Shirwai, in his 4th edition, in his magnum opus, Law of Constitution, in 4th edition, says that there is a very strong presumption of validity of statutes and that no court will adjudge the validity unless the question is essential for adjudging the cause brought before him. First off, there is such a view of the apex court in Ujgar Prince versus so and so. Ujgar Prince versus so and so. Justice M.N. Venkatachalaya's judgment. First off. Next one. Learned advocates representing the respondents vehemently oppose grant of any interim relief, contending that already the judgment in question is implemented. First off, be that as it may, there are arguable points which merit deeper examination at the hands of this court. First off, therefore, appeal is in order of the net single judge is hereby state.
For a moment, my lord, you also can see.
The division bench has dealt with it.
You want this copy?
So where
It's Supreme Court. It arose from Rajasthan. Some research orientation is a must for lawyers. They should do some research, always some research. The Bhagavad Gita says, Nahi jnanena sadrusham pavitra miha vidyate. There is nothing as sacred as knowledge. Therefore, Bharat Bha means knowledge in Sanskrit, light. Whichever date you fix, take some date.
State of Rajasthan versus Prakash Chandra.
Correct. State of Rajasthan versus Prakash Chandra.
1998 Supreme Court, 1344.
98 Supreme Court, 38, 1344. Correct. Make list of those judgments and circulate them to the youngsters. They also will learn. Yeah. July? Last week of July. Give some date. Sirwai.
Yes,
Okay? Sirwai, fourth edition. That page, just put it, I'll put a page there. Yeah.
I don't know. Section number 26 and for the filling, yes, on the last date, notice was issued on the question of limitation.
Limitation.
62 days delay.
62 days.
Yes, my lords.
Will condone delay. Recording.
After hearing your question in the other matter,
He will not
I
argue.
stand to object.
Generally, of course, limitation, Salmond says, limitation is law of peace and repose.
Absolutely.
That's true. But when many older matters are pending here, how can we say that we will not? Appeal filed after broking delay of 62 days. First, application supported by affidavit is moved. First, delay is short. 1/4 and plausible. First, we'll condone the delay subject to you presenting one book to the library. Which book you will present?
My lords, if I may be permitted, my lords, the delay is only caused because I had filed a contempt of.
We are favoring.
Your Lordship, any book, if your Lordship will consider.
Book,
because
we should give to the library. Okay. Good. Law in a changing society by by Professor Vice Chancellor. I forgot his name. Professor. Or how? Aaron Barak is from Israel. All right, you give Aaron Barak's book, A Judge in a Democracy. And you also read. It's a very good book. He's a great judge. He is considered to be reincarnate of Justice Oliver Wendell Holmes. He's a Supreme Court of Israel, judge of Supreme Court. Many books he has written. That famous book, Judge in a Democracy, and the proposition of the law. Beautiful books. Yes. Okay. One book, Judge in a Democracy, to the library. All right.
Yes, ma'am.
Which date you want, sir?
Any day your Lordship fixes.
Last week of. All right.
So, you put it in 64 days.
64.
Whatever the registry
has said, that date I have to kind of. Okay.
Last week of June.
Okay, sister.
Copy of the brief should be given.
Yes, I'll serve it.
Yeah.
Also, kindly. Also, my senior sapiens. Today I filed a workload for my senior sapiens.
Heard learned senior advocate Shri
SP Vishal.
appearing for opposite parties, assisted by the counsel on record, Shri. Sorry. Then,
Item 27, Your Lordships. I'm there on the virtual mode, Your Lordships. Your Lordships, the noting here is that that we have not taken steps to furnish the new address. Your Lordships, we did try to find out. What has really happened is that particular branch of SBI, that's no more there. And the assets probably has gone to another. We tried to make an inquiry in the nearby branches, but no branch clarified the point. So my only request would be if Your Lordships will allow us, or in fact rather direct us, to serve a copy to the counsel who has appeared.
My lords, I have instructions to appear in the matter.
you will appear.
Yes, my lords, I'm appearing on behalf of SBI, but my learned friend is probably not informed because her client has been serving notices on the new address. But in any view of the matter, they can serve a copy of the writ appeal on me. And
You appear for the opposite.
First Bank of India.
That is the only party here.
Yes, my lords.
Lordships, yes, the same branch. It's just that the stress asset manager and also the manager, branch manager has been made party.
The net counsel, panel counsel appears for opposite parties. First up, serve a copy on them.
Lordships, we'll serve a copy. But Miss Mamta Tripathi does not, she doesn't stay here, so I'll have to.
No, I very much stay in Bhubaneswar. They can serve it on me on my clerk.
We are not here to resolve your dispute. We are here to resolve this.
We'll sort it out, my lords.
You serve it. We'll take it as gentle lady's assurance. We'll not record it.
No, we'll serve it. We'll serve it.
Yes.
Obliged, my lords.
My lord, I am for the respondent white mind. So for my friend who has appeared on the
Okay.
issue
notice on application on main appeal and application for condonation of delay. Okay.
Stay application will be supposed to follow.
Just no, until further, we said that till next date of hearing because we can. The applications.
I-8261, I-8277.
Then you have to restructure instead of application alone. Only you can say
Applications. Notice of applications.
appeal and applications. And the last line you said, application allowed, we said, na, we will not say that. Only it is to stay or state and restrained from contracting or negotiating the second marriage. All right. Yes.
May I please,
Yes.
I will invite your lordship to the order dated 21/4/2025.
21/4.
Previous order, my lord.
What is that order? One more.
Whereas senior advocate appearing for the petition submits that DPC for the post of superintendent level 1 typist cadre was held on 18 December 2020 when promotion order was issued on 22nd December 2020. But the petitioner was directed to join the promotional post by dated 2nd January 2021. of the petitioner being allowed to join the promotional post on the date of issue of promotional order, that is 22nd December 2020, he could have got one more
increment
before his superannuation. I am retiring on 31st of. In view of the delay in directing the petitioner to join in the promotional post of superintendent level 1, the petitioner...
He has lost one increment.
No, I am there in service.
You are still in service.
I am likely to retire in 2029.
But because of this, you will be losing one increment.
Yes, ma'am. So that is precisely, your lordship may bear with me a little further.
Not losing.
In view of the delay...
That's why. It will be delayed. Accrual will be delayed.
Yes. In view of the delay in directing the petitioner to join the promotional post of superintendent such as the petitioner is deprived of getting his last income.
Not deprived, but delayed.
Your lordship language, I can't...
Maybe correct. Either.
I don't have the liberty. So, Mr. Deora, the additional government advocates prays for an adjournment to construction and file an affidavit of the competent officer explaining the same. They had filed and counter affidavit. In spite of that, your lordship directed them to...
Had you joined pursuant to the order of promotion, you would have gained one increment.
I joined in 2nd January post, 4th January, but I am officiating in that vacant post since 1st of July previous year.
You are already officiating in that one. It is by way of in-charge arrangement.
No, my lord. Let me explain. 36/6/2000 was asked to officiate in that post from that day or next day.
You were already there.
I was already there when this DPC came and all that. So on the 18th of December that year, DPC was held. Though there are circulars and other directions that DPC should be held well before the consequence of vacancies. I place that, my lord.
Mr. Sodangi, may I actually?
Yes, sir.
Is that when the notices were for promotion issued on 22nd of December,
sir,
2020, the post was available, but you did not join.
No.
Or you were
I was already there.
Kindly. So then the formal joining letter was to be issued by the authority.
By the authority.
That could not be issued on that particular date.
Yes, my lord. It was issued on 2nd of January, consequent upon which I joined on 4th of January.
Any reasons according to you disclosed?
No reason disclosed.
What is
after
again, sir? Still he is in service.
Millets after available of vacancy on 2020.
Vacancy arose on which date? On the retirement of other person.
Yes.
Vacancy arose on which date?
Annexure 1 page 10 is
We are asking the date, not the page number.
June 2020. 36 2020.
This vacancy arose because of
retirement of one Simachal Paikra. I have Miller's mentioned in my counter.
And he held the post. He was placed in charge. He was officiating, na?
Yes, Miller. DPC was held Miller thereafter.
That's all right. See, afterwards we understand. That was in December. What he says is, I was officiating in that post because I was placed there after the vacancy arose on account of retirement of the predecessor. That is his case. If that is so,
he is in charge.
He is in charge. He is holding the post. So you are asking him to report for duty subsequently is insignificant.
Who was in the Miller's
in charge arrangement?
Senior clerk in charge of that superintendent on superannuation of one. Miller's.
No, best case also on 20th of December when you gave him promotion.
He was already in the post.
He was already there and he got the promotion.
Not promotion Miller, because promotion got on Miller's that is 4th January 21 Miller.
No, you are disputing his date.
Yes, I am disputing.
Before we go to this controversy, what is
let us see the order.
See that.
My lord,
there is an order.
Page 10.
No, 21/4/2025 of the order of our predecessors, other bench, coordinate bench.
This is possibly not correct.
Not correct.
This is possibly not correct. Your lordship, I take to page 10, which everything will clear.
Your appeal memo?
Yes, my lord.
Please take to page 10.
In pursuant, my lord finds that.
Pursuant to district
office order number such and such, voted such and such, communicated by such and such. Sri Simachal Paikra, Superintendent Typist 1, District Court, Fulbani is hereby relieved from his duties today, 30th June 2020, afternoon, in the eve of retirement on superannuation. Further, Sri Paikra is directed to hand over the detailed charge to Sri Joyanta Kumar Rao, the petitioner before my lords, Superintendent typist 2, level 2, district court Fulba immediately and Sri in addition to his duties until further notice.
Correct.
Inform all concerned accordingly. Annex 2, page 11.
In addition to of his own duties until further orders.
My lord.
Therefore, you were discharging the duties of that post also.
Yes.
In addition to yours.
Mine. In Annex 2, page 11.
So
Here-
where is that order which is refers to as a promotional order or result?
That is
Which
11,
page?
Page 11. Page 11, Annex 2.
4120.
Page 11 is not 22nd December or 20th December 2020 order, which Mr. Sarangi is relying. There is relying.
Where is that order?
So that the result of the promotion was published.
That is not in dispute.
This may not be in dispute.
Nice, sir. My lord is right. My lord.
Can we not see that, sir?
Yes, my lord.
Why there was so much of time is spent in finding out that the page or the annex?
Nice, sir. Seta, that is not there.
Where is that order?
Not annexing company.
You have not annexed that order. Do you have the order copy?
No, sir.
You don't have. That may be required. Do you dispute that order?
I have to check it.
We have to produce that copy of the order. Do you have a copy? We will pass it over.
No, not that way, lordship. I don't have it. I can ask for it from my.
You want time?
If that is something, my lord, I have to produce
Yes,
it.
because you have to see the text of that order.
My lord, 1 minute or 2 minutes of my lords. Kindly turn to the date chart that I have filed.
Page number?
You can see because you are the opposite party.
You have those. Why he should lose one increment?
In fact, DPC
You produce that. Everything will be clear if we see the text of that order. If that order says that he is promoted with effect from such and such date, then promotion takes effect.
It's not a promotion.
Check it, sir.
No, it depends.
I will check it out. That is not a promotion. Promotion actually 4-1.
You are saying that.
That is the
But the
order.
court we have recorded the other that was on 20th December 2020. There is a record. The order is there. Therefore, at least it can clarify what is what. You bring that copy.
So also the DPC, your lordship, asking.
DPC proceedings.
Yes.
Learned the AGA shall produce on the next date of hearing a copy of the DPC and the promotional order followed by it. But after serving copy of on the learned council appearing for the.
I will produce original record.
Not original, just produce it. It's not after all. Just copies will do.
Who believes us?
We believe you. Unless you do something which will cast doubt.
No, sir. I am not personally. I am not that kind of philosopher.
Okay. On the next date of hearing. Call this matter on 7th of July.
Only DPC time. DPC.
Consequential
DPC
order.
and consequential promotional order.
20 seconds order. 7th of July, my lord.
7th July.
8th.
Be all right?
Let it be 8th.
8th. On 8th July.
Is it not little too far?
Huh?
Why I was placing the date? Anyway, let him come then.
Let him come.
At one go.
That's what.
Yes.
And challenging Annex 5. Lordship may kindly show the page.
Yes.
Page 3.
This is miscellaneous appeal.
No, that is not. This is the.
worker.
And as per the advertisement, a condition was there that she must know how to read and write.
Must.
That is one of the conditions. I have applied and OP number 6 also applied. She was selected as she secured the highest mark in Metfullness. 10. My lord, I challenge the same by filing an appeal before the ADL, stating therein that she doesn't know how to read and write Odia because she passed her CBSE from Delhi. So she doesn't have
No, Oriya.
That is my specific stand.
That she does not have.
That she doesn't have.
What the learned single judge says?
My lord, your lordship, I first turn to Annexure 4, the order passed in appeal.
What he said?
My lord, in appeal, it was the entire process was cancelled, directing the authority to do it afresh. Because
that was challenged before the single judge.
Yes.
Single judge set aside.
Because this it was set, the entire process was set aside on the ground, which was produced by OP number 6, that she is having the qualification, is found to be fake.
Turn to page 21 of the recap. This is the order of the Lord ADM, who have a basis of merit list and residential certificate issued by the Tahsildar Bijapur in favor of the respondent number 1. Further, it is stated that as per the clarification received from the Women and Child Development Department by letter dated 22/5/2010, the candidate who apply for the post of Anganwadi worker must have knowledge in Odia. The respondent number 1 speak, write, read in Odia.
Client is here.
No.
Your client is here.
No,
we'll ask.
Possible permit me. I'll call tomorrow also.
Tomorrow you will give dictation in Oriya. My brother will give dictation in Oriya. Let me take.
Then your estimate
Everything will be.
Then page 11 also can be similar advertisement.
The case is she does not know Oriya. Therefore, prima facie you have to demonstrate. She knows reading and writing Oriya. My brother will dictate in Oriya. Let her take dictation. Let her see.
No, that was not the issue. I was produced by that board certificate and everything. But when that appeal was filed, in that appeal I did not contest law. There, one fake certificate was produced by somebody else, and it was my stand before this honorable court because that was not necessary at all.
It may not be necessary. Whether that certificate is fake or not, it will touch the conduct of the party.
Yes, ma'am.
Therefore, we have to examine who had produced that certificate.
No, that certificate, my stand, that I have not contested the matter.
That's all. And who had produced that?
I have not
produced that.
That might be the that appellant who has filed that case to.
That is not your stand.
No.
Yeah, before this one also.
Else will produce that.
Can you read the actual finding in that regard or submission para 5 of the judgments?
This one course. Yes, ma'am. Right.
I mean, at times, so the way you are arguing that it is not necessary to produce it.
That's another thing.
That's another thing.
But if you
yes, madam. Coming to the question of submission of fake certificate, it is submitted by Mr. Oza that his client had
internal page 3 para 5 starts.
Page 30.
The ADM Jajpur issued notice to the appeal to the Sunita Malik as well as CDPO Binjarpur. The CDPO in his written submission stated that as for clarification received from the WCD department dated 22/5/2010, the candidate should have knowledge in Odia and that the respondent number 1, Sunita Malik, can speak, write and read in Odia. Therefore, the selection is genuine.
So that part is correct.
Yeah.
Next part is in course of
hearing, a certificate issued by the Ahmedpur Primary School, Rajkavita, Kendrapada was submitted on behalf of Sunita Malik, showing her have passed the class 5 in Odia medium. The genuineness of such certificate being challenged by the appellant, the Director of Social Welfare was asked to issue clarification. Accordingly, the District Education Officer Kendrapada certificate is fake.
The person who uses fake document, what apex court said in general over a 90.
By my humble submission, it is my throughout stand that since on the basis of the documents I have already been selected,
So that you know
that I considering the case, it is not before the authority selection authority or any other authority.
Then you should have challenged the order.
I have challenged that order before this
The authorities saying that it was a fake certificate produced by Sunita Malik.
on behalf of Sunita Malik.
On behalf of Sunita, who will produce?
That malad I don't know.
And it is issued by a particular school name.
School name.
Last name is given.
Yes, madam.
Your name appears.
Yes, madam.
Who else will produce? Read section 114 of the evidence set. Give evidence set. Kindly read section 114 of the evidence set. Court may presume, regard being had to human nature, conduct, etc., that certain things have happened.
Yes.
We presume that you have produced in that way. Nobody else is interested except you.
That aspect also, this honorable court has taken care of. Paragraph 8.
Read section 114 of the evidence set. So beautifully written by Shripad.
Yes.
Read.
Court may presume. The court may presume the existence of any fact which it thinks likely to have happened, without being hard to the common course of natural events, human conduct and public and private business in their relation to the facts of the particular case.
Yes. Who else will produce this certificate? Your name appear.
Yes.
Oh, some third party is not interested in you.
No, in fact, that fake certificate, on the basis of production of that fake certificate, that benefit goes to the appellant only, not to me, because I have already been selected, and as per the advertisement, that she has to read, write, and speak in Oriya, and that committee has already
benefit much before the issue is being decided. You see, the application is invited. And in your application, once this certificate is there, that is the statement.
Certificate. No, perhaps I am not correct.
No, you are so clear that I am able to understand.
No, that certificate was not produced at the time of making application.
When it was produced?
It was produced only in court. But my stand that I have
no
not.
other person can produce a certificate in your favor. You only will produce that certificate. You could have said at the earliest point of time, sir, I have not produced this certificate. And you have not said that.
That on the basis of that certificate, Lord and ADM has passed the order immediately for this honorable court.
On the ground that you have not produced the
Yes,
certificate. Where is that?
Yes, your lordship kindly.
Who else will produce the certificate?
I have taken the stand, Lord, your lordship kindly. Your lordship may accept the but your lordship kindly. For the first.
Just one, sorry for one interest. I think gone through the order sheet in that proceeding, when it was produced. You challenge the order of the ADM, who statute of and of that appeal. So when the ADM has recorded of finding of that certificate in its order.
Final order, Lord, the ADM has indicated.
I will check that, sir.
On the final order that has been indicated, and that order I immediately I have challenged this and I have taken the specific stand in para 12 of my writ petition indicating that I have never contested the matter before the Honorable Tribunal.
No, not contested. I have never produced that.
Yes. Your also
Read that one sentence.
No.
No other person can produce it.
No.
How they came to conclusion that How he came to the conclusion that you know that reading, writing.
Selection committee has tested me. Selection committee.
On what basis?
But they have called me. Yes. And selection committee called me. They have tested me. Then they have indicated that she is able to read, write, and speak Oriya.
There has to be some evidence in that.
Selection committee file must be there. If your lordship,
you are the person who have to defend that.
There can be end of Oriya test.
Yes.
Or essay, or representation.
Yes.
So, and it is universal. It can't be tailor-made for you and for Jan's client, somebody, some other.
Has to be on the basis of that.
Your lordship, kindly turn to page 32 of the deed. Page 32. The order of Honorable Single Judge. Yes.
Then come back.
It requires, the advertisement prescribes that you should know, the candidate should know Oriya, both reading and writing. That cannot be ascertained orally by the selection committee because it is not statement called. It has to be ascertained on the basis of documentary evidence like school certificate, college certificate, certificate issued by some competent authority. It cannot be by just talking to a man. That has not happened here, number one. Number two, your conduct disentitles you to any relief at the hands of the court. Because we assume, and there is reason to do that, no other person would produce a certificate and that would inure to your benefit. Who else will produce? You are the beneficiary, possible beneficiary of the certificate. The Supreme Court said in Changalavaraya Naidu versus 94 Supreme Court, referring to Lord Edward Coke's statement, fraud, fabrication, duplicity, vitiate everything, unravels everything. Okay? Therefore, right, that is reiterated by the Apex Court in Meghamala. Meghamala, do you have that judgment? You don't. 2000? Therefore, no relief can be granted. This writ jurisdiction is not meant for bad people. If you see the history of writ, these are all king used to, in England, king used to exercise writ power. Then he shared it with his judges. Therefore, persons who come to court should have clean hand, clean head, clean heart. Only to them relief can be granted, not to persons of culpable conduct. Going by these standards, relief has to be granted to the appellant.
First submission. But my standing at the time of application or selection, I have not submitted any such document contraband document or false document before the selecting authority. That was submitted when the appeal was filed by the unsuccessful candidate before the ADM. There, my stand is, in the writ petition, I have challenged the order of the learned ADM with the stand.
You have not produced.
Never submitted that document.
We have noted that. You need not repeat because we remember.
Again, I said on the cost of application. Neither that document was submitted along with any affidavit.
Your case is that you have not produced it.
No.
Understood. Go to the next point.
Then your Lordship kindly turn to that aspect also has been taken note of this honorable court. Your Lordship kindly turn to page 30. Only one full paragraph I can.
Very good. Very good.
Yeah.
Which paragraph?
That one thing has been quoted, your Lordship kindly see, that has been quoted in between.
Srimati Sunita Malik.
Yes. That just above I've seen that I will read fourth line from top. As has already been stated hearing before, the CDPO of Mirzapur in her written submission before the appellate authority clearly stated that Sunita Malik can speak, write and read the Odia. Even before this court, the CDPO in her letter addressed to the Advocate General on 31/2023 stated that Srimati Sunita Malik secured highest mark as per the evaluation. Srimati Sunita Malik secured highest mark as per the evaluation. The committee during the interaction with the candidates on the date of verification was convinced that Srimati Sunita Malik could speak and understand Odia. She also able to.
So actually, we are not there. We are not there. We are, in fact, we are perhaps we are very sure that Sunita Malik can read and write Odia. That's not the point to be adjudicated. Perhaps what fell from my lord as we arose for the lunch, that whether in the selection process, how the authorities arrived at a conclusion that she writes and reads Odia. Either it has to be prescriptive in the advertisement rules. So how did it happen? So in fact, actually, it is an argument against your contention that, like, yesterday only, that can the CDPO supplement the
what is not there in the advertisement?
He had no occasion to write to Advocate General, the Advocate General or the Additional Government Advocate to know, for us to know that whether she writes and the selection committee arrived at a conclusion.
No. She can read and understand.
Read and understand.
Word right is absent.
Read and understand. So
read and understand. What is the requirement?
Read and write.
Read and write is requirement.
Read and write.
No, the English translation.
That is candidates should be able to read and write.
Lekhi is right.
Yes,
but he is
read and write.
Read and write.
Then below the Lordship, let me to complete.
No, CDPO.
Yes, sir.
In her letter addressed to the Advocate General, why she addresses we do not know. On stated that Srimati Sunita Malik
highest mark
as per the evaluation and stated as follows.
The selection committee during interaction with the candidates on the date of verification was convinced that Srimati Sunita Malik could speak and understand.
Speak and understand.
Next, she was also able to sign in.
Sign in Odia. Signature can be done in Latin. I can put my signature in Latin. Because Supreme Court said, sign can be anything. It can be the foot of a kite. This is what it could say. Question is not signing. Anybody can sign.
Yes.
The
question is reading. Reading is different.
Yes.
And the language used further can read. The committee was convinced. Convinced that Srimati Malik secured the highest mark. What is there to be convinced in the mathematical? Somebody secures highest is highest.
Yes.
You don't have to convince that 4 is greater than 3 or 2.
That's what.
Coming to the question of submission of flight certificate, it is submitted by Mr. Oza that his client has no knowledge of submission of same and her advocate may have produced the same before obtaining it.
How her advocate would obtain?
Right?
Unless she gives, how her advocate would obtain it? That's it. Advocate is an agent of the party. If advocate produces something here, it is as good as client, the litigant producing it.
No, but this thing has to be some report has not been. Your Lordship, this is a totally unbelievable plea. This court has not believed that.
Yes.
Nevertheless, it is seen that the district education officer Kendrapada in letter dated such and such informed the ADM Jashpur that after verification of relevant records of the school, the headmaster stated that school leaving certificate issued in favor of Srimati Malik is a fake and false one. Copy of the letter dated 3/1/2022 of the headmaster was also enclosed to the letter of DEO. This court has already held that conditions of engagement as per guidelines issued by the government in W and CD department do not mandate that the candidate must possess any qualification in Odia. All that is required their ability to read and speak in Odia. The selection.
Can you stop there? The requirement is
read and write actually.
Not read and speak in Odia. The selection committee categorically observed that Srimati Sunita Malik is capable of speaking, writing and reading Odia. It is nobody's case that the finding as above of the selection committee is erroneous.
No, Mr. Bojha, actually, can we read that slowly? When you are missing certain things. All that is required is the ability to read and speak Odia. Is it correct or wrong interpretation by the court?
Then next.
No. That's
observation.
Observation. All that it's a court's observation. We can't improve about.
That is part of the observation. Then next line.
Correct. So according to you, all that is required is read and speak or read and write. Lekhi padhi or lekhi kahi.
That exact wording is
lekhi padhi.
Lekhi padhi paruthi.
Yes. Lekhi kahi paruthibe to koti lahi. In fact, somebody who is unable to speak Korea can easily argue.
But one line cannot be taken into isolated way.
No, I'm not arguing with you. It's a question. Either you know the question, then you answer it. I have a difficulty. Suppose you don't want to answer, I'm not asking.
Sorry.
No. Please answer knowing the. So the criteria is lekhi padhi.
Lekhi padhi.
Can you change it to lekhi kahi? The question is, can you change it to lekhi kahi?
Then next, that has been lekhi kahi and padhi paruthi.
So
next been indicated there.
No, next is very interesting. Now the next line is, all that is required is their ability to read and speak Odia. The selection committee categorically observed that Srimati Sunita Malik is capable of speaking, writing and reading. So can you read just above? Can you read just above, para 8 above? Read it. Where it is written only speaking. Speaking is written.
That is
the difficulty is that ADM was the finding code. Correct. So, and it has to apply. The selection committee has to apply the notification criteria. So, a read court has to find fault in finding of the ADM. Now, in fact, this observation in paragraph 8, it has changed from lekhi padhi to lekhi kahi. And the report of the CDPO says, whatever has been relied, you call it a Bible also. The Bible produced by the CDPO. So it's immaterial what I am calling it. It is taken note by the court. It's taken note by the court. It says she was also able to sign in Odia. Srimati Sunita Malik could speak and understand Odia. Bujibe. Then she starts another word, bujiba. Lekhiba, kohiba, bujiba, podiba, everything has been changed. So according to you, which is the criteria? Best suitable to you.
Lekhi podi.
Then you are so fair, then we can't also go beyond that lekhi podi.
Yes, sir.
Lekhi podi is, lekhiba is right.
She is able to read and write not.
So how that should be our question here. It cannot be by interaction. It should be evidenced by some educational certificate. That is otherwise they would have said the selection committee shall ascertain by talking to the candidate as to whether he or she knows reading and writing. That's not the a person who has studied in Delhi. What is that? Delhi. Delhi. These are basically these kinds of appointments are meant for the locals.
But she is Oriya girl.
Maybe Oriya girl who has applied to Delhi. Therefore, who was not able to fly to Delhi should be preferred.
No, prosecuting
higher studies.
No. Last 10th class from Delhi.
From first to 10th.
CBSE doesn't read it.
CBSE
1 to 10 she has studied.
How she will write? How she will write, read and write?
But she is able to write.
That is what you are seeing all through, even before the lunch hour.
This honorable court has called for the records from the selection committee, and this honorable court has observed that your lordship may kindly see that selection.
Otherwise, we'll be giving lot of discretion to the selection committee. That those who come from Karnataka, no, because I'm here, they will say he knows Oriya to speak, read, etc. How to ascertain? So that will not be on normative basis. It should be some evidentiary, so much discretion, granting enormous discretion to the committee runs counter to the rule of law. The very object of rule of law, curtail discretion, make the things normative at any standard book.
And if your answer is repeatedly, that is how we are asking you. If your answer is that yes, the selection committee has the discretion, yes, but you are fair enough not to say that no, they
saying about the discretion of the selection committee. My submission to determine these powers conferred upon the selection committee by the statute or guidelines.
Now, where is the conferment of power? Show that.
That you also may kindly see the advertisement.
Just show that. That they can assert by interaction.
Guideline page is there or what is?
In fact, so much time spent on this matter. We have understood. We have understood. We have repeated. We have understood. We have understood Madam's case also. And the person who has inserted a fake marks card or some certificate cannot be favored by the writ court. Writ court is not for to borrow the words of some judge in Allahabad. Writ court is not meant for loafers. Well, we don't use that word because we don't agree with that word. It's a slang word. But they conveys the message. Writ court is meant for honest gentlemen, honest gentlewomen, not for persons of that nature. That is the inner voice of that Changalavara Naidu, the Lord Edward Coke's judgment. Changalavara Naidu reiterates, and then Meghamala. Therefore, we are allowing the writ petition.
Lastly, only one line I've said, Lord.
Again.
Yes.
So it's a neutral order. I mean, suppose like one yesterday Lordship has rendered a judgment that debarring for all future time because you do not read and write Odia. And reading and writing Odia, suppose is not there is no educational qualification, one can learn it. By this time you might have learned also. The whole exercise of challenging this order for fresh advertisement. These things have to be looked into also.
Of my selection, because one of the
it's rightly done. It is rightly done. Let him not do. We are whatever power the ADM has, we have that power. The power of the writ court is coextensive with powers of the authority whose proceedings are called in question. Kalinga tubes. Therefore, we have power, all the power which the authority would have had. Therefore, what he should have done, we are going to do. We are setting aside your appointment. We have seen person of that kind. So he has said, that's that fresh advertisement, it has gone. But why fresh advertisement? If he is appointed, the candidate next in order will come into the fray.
She seems happy with this. He has not challenged that.
You have not challenged that one?
Yes.
She is before this court.
That as per the guidelines, once the person is appointed and for any reason that has been cancelled, That's a face.
No, not always. Not always. Shall kindly quote one judgment like that.
No, that is in the guidelines.
Sure.
Possible trying to keep this.
No, not question. We never do things on installment basis.
No.
We have heard you enough. We have heard more than what was due to you. But with this one.
The ADM order will stand, then face
ADM's order you have not challenged. Which petition?
That is repeated.
Another
16096.
So naturally, candidate next below will be entitled to gain entry to the recruitment appointment. Employees.
And the entire order sheet I have also filed along with that petition.
Order sheet of the ADM.
ADM.
So she has produced, it is recorded.
Yes.
At least it is produced.
No.
It has been produced from the.
No, the other problem is that the ADM went on investigating that also.
Yes.
He wrote to the CDPO,
Yes.
the application officer. He has done exercise. He read.
No, even that question will not arise because he disowns the certificate. Therefore, that question will not arise. If you disown the certificate, then question will not arise. Therefore, the candidate next below has to be granted appointment. That's the way Ramaji speaks.
Your writ petition is dismissed?
Yes.
Dismissed.
This is allowed.
Common judgment.
A common judgment.
So, the petition appeal has to be the advertisement, fresh advertisement direction to be set aside.
So that will be the order.
That will be the order. Reason follows. Judgments which say not subjective at all. Otherwise, you will be wasting enormous discretion at the hands of the selection committee, where so many things may happen. Yes, brother.
State appeal was against the judge order dated 74/23. Honorable single judge was directed to give promotion to the petitioner by opening up sealed cover during pendency of the vigilance case as well as independent proceedings.
Sealed cover procedure was followed.
Millers, two ground millers, that is millers not given opportunity to file counter before the single judge. That is a principle of violation of natural justice.
When notice was issued, whether it was on the date of admission itself dismissed, allowed?
Order number. Page 16.
When petition was filed?
Petition was filed, my lord.
When the petition was filed? When notice was issued?
6/4.
6/4.
6th February 23.
6 February. 23.
Order was passed.
1 second. When notice, your notice was heard on?
10/4. 10/4. Presented on 10/4.
10/4. Yes. WP filed on 10/4. 10/4 it was filed.
Yes.
It came before the court on which date? 17/4. Did you seek time saying that I want to file objections? Where is that? Now tell us. What is your objection? Now tell us. Had you given how you would have improved the case? Tell that.
The millers during vigilance case millers, the promotion shall not be given millers as per the millers.
Correct.
Coordinate bench also given a judgment annex of 3.
No, what happened to vigilance case?
Vigilance case will the status of vigilance have no instruction to that.
Then without that, how can you
Right
act?
now, right now. So I'll take status of the vigilance case will
I have filed. I have put, sorry.
You have
put, yes, I have filed the.
Clear?
And
Vigilance case is also.
Vigilance case, my lord, till date, charge sheet has not been filed. No
Charge sheet
company
has not been
no.
filed.
I have given
That's a their contention.
No, no, I
Right
have
now,
given the
I have.
certificate. Lower court record.
See, dependency of a proceeding, when it happens, vigilance,
That is only-
when after the charge sheet is filed.
Yes.
Not
That is the
before.
law, my lord.
That's
So that
different.
is the law.
Criminal proceeding initiated at the time on registration of FIR.
No, what the rule says. I think there is a judgment of apex court on that.
Yes. If Janaki
Ah,
that is
Janaki
the only
Raman.
judgment we decide. the issue.
Janagram paragraph 6 and
Paragraph
said
6
that all
that
charge sheet
decides
or
issue.
charge member.
Charge issue. So that is why.
That is
Have you issued charge memo?
Charge memo is for DPC.
DPC.
Charge memo is DPC, charge sheet is
two
for
things
the-
are applied.
Correct.
What is the
There
other
are
thing?
subsequent decisions also.
Yes, many things.
No, but Chaman Lal Goyal is not Chaman case. Chaman Lal case, the honorable civil judge relied Chaman Lal Goyal.
Not exactly. But my
No, not exactly. Chaman Lal Goyal is not applicable because it is on disciplinary proceeding.
DE is different, criminal proceeding.
yes, this is now we are in criminal proceeding. My lord,
So there are
once-
at least
I should have not
some
had
good
that
number of
judgment.
decisions.
My lord probably knows that Justice Aimathi's judgment, my lord, was there.
No, my understanding after reading few books, I have not read as much as you have read. But at least, no, really, Rama Joyce I have read, Samaraditya Pal I have read, Kulashreshtha on legal remedies in service law. These things I have read.
Yes.
They have said a disciplinary proceeding is initiated when the charge memo is served on the delinquent employee.
That is the law.
A criminal proceeding is instituted when the court takes cognizance of the complaint
Or the
and
charge.
frames the charge.
Or the charge.
That's what charge sheet is for.
Charge sheet is-
Charge sheet.
But here in this case, my lord, charge not yet been filed.
What
I
the
filed
learned single
certified
judges,
copy.
what the learned single judges.
From that to the charge
I
sheet.
filed-
That
can you see
at
the-
present charge sheet has been filed. or
No,
not?
no, sorry.
That is at the
I
time of
filed the
writ-
certified copy
At the time of
obtained on
writ itself.
6 on 7.
Even at the time of writ petition, charge sheet was not, charges were not framed. It
On
makes
se-
your case still worse.
7/4/2025, I have the order of the learned court below.
Case is posted for.
10/4/2025.
Ah,
At that time, I am given it, I am just reading out. Accused Shiva Prasad Malik is present in the court and the file Hajira has not yet not been received. Put up on 7/7/25.
Final-
Final
Final,
of the charge sheet.
final report 173.
Yes, that is in form of a charge sheet or a closure. Two things can is possible. Final form connotes two things.
Charge sheet or
Charge sheet or a final form closure of the case.
closure of
Police, it is up to the police. So now the charge sheet in this particular case has not yet been filed. So they cannot term me as an accused in view of the Janaki Raman judgment. Honorable Supreme Court has held. It
So
is
since he pleads lack of instruction, give him some time.
I have.
Now he put notice also. Of your content.
I have given the copy.
We'll call this matter next. Matter lies in a narrow compass.
Yes, sir. This is
But
not point.
judge given, see, even God had given an opportunity of hearing to Adam and Eve.
I have no notice
Ah.
on that.
You
But
can
since
just
I have
decide the
given
case without notice to other side.
Yes, but since I have given the certified copy and given a copy to him,
Very understood.
that much I can impress upon him.
Understood.
No,
Let's call this
I
matter.
counter on it.
Post
Next.
Janaki Raman has been subsequently discussed in Bansal, Yuval Kumar and H.C. Purana.
Yes.
Purana.
But
So they have said that because that confusion is charge memo or charge sheet, whether because it has
The CRPC does not use the word charge sheet.
Charge sheet.
Yes, that is
Final. Final.
So what is
Final report. is-
Final report
Yeah.
only.
Yes, sir. But that's how we have done that. Anyway,
developed?
now according to you, the charge sheet is not filed.
Yes.
Therefore, not only filing of charge sheet, framing of charge.
Yes, that is a subsequent.
Subsequent 229, 228, 229, 228, 229. Or it may be 239 also.
239 incessant
I
case.
will do this one. Anyway, this matter.
But once charge sheet is filed, once FIR has been filed and subsequently forwarded to the court and registered as a VR case or something.
No, that will not be.
you are saying cognizance taken.
Vigilance. No, that is not.
You are saying cognizance taken.
Once charge sheet.
You examine
I'll
all the
let them know.
cases.
Okay, let me come back.
Yuval Kumar, all these things.
call week after next.
How's it before?
At the request of learned AG.
Paperless.
AG. Share a copy of Janki Ram. You have? One way which Settlewood suggested to his juniors in his famous book, autobiography, Law, Life and Other Things, is taking the decision, first decision, then how law developed. Law has graphical movement. Sometimes it goes, sometimes it is a snake and ladder also. It goes up and comes down like many judgments, not one or two. So you have to work out that way. The first proposition, when it was laid down, how various courts treated this proposition, whether proposition is widened in scope, shrunk. These things you have to examine. That's the way. In fact, that is the best way of learning the law. Of course, you know that. Yes. You give your account number. Counter is not received. They choose not to file counter at all. We can't direct them to file the counter. It is like filing the WS. You stand to gain by their not filing the counter. We will take your version as correct. Yes.
This may allow huge time. Pharmacy council is the number 2. It is very small that he is required to take a renewal. If this is, let's see the moment for the rejection or annex of 9 phase 32.
Before that, if you are ready to argue, we will take up the matter. If you want to file objections, don't waste time of the court.
I am appealing to 46, my lord. Has been noted also.
Okay. Call this matter. Appearance to be.
And if just write in a piece of paper, so many parties are there, so we'll have
Number 6.
Copy number 6.
Who have rejected the application. Odisha Pharmacy
He
Council.
is answering a response. Call this matter. On that day, again, no prayer for adjournment. That day, you have to argue the matter. Again and again, we cannot read the papers. It is very tortuous to us. Yes. Call this matter. Please choose a date. Whichever date.
After 3 weeks, any time.
Call this matter on some date to 3 weeks. Give some date.
July.
3 weeks.
3 सप्ताह.
Recruitment. At the request of answering respondent, counsel for appearing for the respondents. Finally. Yes. In the meanwhile, it is open to the respondents to file their reply or objection. What is that? Counter affidavit. Failing which, the right to file one stands forfeited. Yes.
I am for the petition from next week.
You want time?
Mileage.
The nursing council is the party, let them serve a copy.
Give copy.
Mileage.
Call this
You are for the National Nursing Council, not state.
I am for the state. I am for the state, for DMT and also council. 213.
You are not present in the last matter.
Last matter, my lord, I have not given the copy. I don't know. I saw my name just now.
How much time?
So, one.
2 weeks for filing objections. To call this matter after 2 weeks. In the meanwhile, it is open to the respondents to file the counter affidavits, if any, failing which, right to file one stands forfeited. Yes.
Pass on the sleep, my lord.
Impulse. Appearance. Of those they will not file objections. I've seen these people many.
I received the format, my lord.
You have received When did you receive that? Which is the date we received it? See the forwarding letter, it will have a date. Yesterday.
6 months.
You want 2 weeks, same order. If you do not file, you will lose your right to file the objections. We'll take the pleadings of the other side prima facie as true. Yes.
There is 2 cases.
Office objection.
First case, second case. Both of these similar, I think. The first one has tagged my case. And the second case, there is some typographical error with regard to the name of the party. So I have filed a petition that IA is 6505 of 25.
We'll allow that application.
Formal. I have filed the application.
You have filed the application?
Yes, that is there on record.
Learned counsel appearing for the appellant points out that he has filed an application seeking rectification of a typographical error at page
in the name,
in the cost title,
DAS, DSH.
in the cost title,
And make the correction.
and that he be permitted to make effect the rectification thereof. First, application is supported by the affidavit.
Yes, I
First,
6.0.
no objections are rightly filed to the same. First, in the above circumstances, application having been favored, leave is accorded to effect the rectification in the rectification before the next date of hearing.
There is still
Registry to permit the exercise. Call up to 2. Yes, sir.
Till date 5,000. And
5,000.
He is to pay another 5,000 because he was not able to the order. He is ready to pay
Remaining amount.
Till that he is paying 5,000.
Every month he has paid 5,000. So 50% he has paid. So remaining 50% he has to pay. Let him pay that first. Then we will have his say, whether it is right, wrong, etc.
Whatever area and
if he makes payment, he need not come.
next time you will not come if he makes the
If he makes the payment, which I think in DS Nakarite said that, I think in DS Nakarite said the commutation cannot be beyond 15 years, no? It was earlier 12 years. They have made it 15 years and that you have challenged here.
Yes, ma'am.
As on the date you retired, it was 12 years.
Yes, madam. That was 12 years because
When you demitted office?
I remitted on 31st March 12, 2012.
31/3/2012.
Yes, madam.
And at that time, what was the GO that was in obtainment?
At that point of time, madam, it was 12 years.
12 years.
And there was
GO dated? Policy dated?
Government order dated.
government order dated 12 years. That was the rule, Milots, at page
That was rule itself.
Yes, Milots. At page 6, rule sub also.
Just give us a moment.
Yes, ma'am.
The right to communication.
Yes, Milots.
File counter. We file counter.
No. See, it's a very simple thing. See, when he retired on 31/3/2012, the policy, what was the rule? You will say 12 years. 12 years, it will be restored. Now, subsequently, you have amended. Amendment is with effect from what day?
Annex 3 is Milots Kerala High Court order.
We are asking that you. Similar on which day rule was amended?
The rule was amended, Milots, 2015, 4/9/2015.
And you retired on 6/11/20.
No. 31/3/2012.
The rule was the rule earlier. Which is that rule?
This restoration of pension rule on 4/9/2015, the Finance Department, Government of Odisha, Sub-Rule 1, Rule 7 issued a notification in which they have amended Sub-Rule 1 of Rule 7.
The short grievance of the petitioner is as to amendment to a particular rule governing the restoration of commutation of pension. which was earlier 12 years when the petitioner retired on 31/3/2012 and which became 15 years while commitment dated 4/9/2006. First, the counsel for the petitioner submits that the Kerala High Court and Punjab and Haryana High Court have taken the view that the rule position as on the date of retirement would be applicable to the cases and that the subsequent amendment
Yes, sir.
I don't agree.
Don't make any submission. Prasad is there.
Yes, sir.
The present criminal appeal is arising out of the past by the learned ad hoc session judge first court Kataknagar in session time case number 55 of 2023, my lord, arising out of Kanpur case number 17 of 2022. On the case of the prosecution before the court below was that
Mr. Khandatra, if you don't use the microphone, your colleague and the VC will not be able to hear you.
Even we will not be.
Now it's because it's in a hybrid mode. You must understand. I think Mr. Panda is appearing. So you speak to the microphone there. Give time your license.
This is a hearing.
Hearings. We've reached hearing.
Actually, possibly because I read the papers.
Take time.
Paucity
of time.
Lady has passed. Constable is looking. And for the informant, her father. On the last occasion, I understand that it's too late to deal with the.
No, we have not gone through papers.
Yes.
We cannot go through the
Order
paper.
I wanted to, last week there was a peremptory order for, Lordship will fix a very short date. This man, if your Lordship wants, I can quickly simplify this for your Lordship.
Yes.
There's a convenience note on record, but we have hard copies.
Yeah.
So that my friend for the state can also concentrate on this.
Correct.
You have appeared in GCRL 5.
I'm in the criminal division.
450.
Well,
I mean, that's against accuser.
Against that. Government is also against that.
Yes, the government appeal.
So selling together.
We are
Selling
selling
together
together.
separately.
No, Lord, the parameters are different. The parameters, my lords, are different.
Different.
Now, after in case we was just
In the event we agree with the appeal, then the revision pales into insignificance.
Yes. This is just to cut.
That.
The date of occurrence I have given. The names of accused persons are Mrityunjay Narayan Ponda. That is A1. He was the officer in charge of the police station. All three people are police officers. Accused number 1 was the officer in charge. Now, accused number 2, Withdrawal Kishan Pradhan, was the constable. These are two accused persons. The name of the deceased, I'm not taking her name. There's a rape allegation. She was also a constable. These are the three main characters. Now,
What was her age?
she was unmarried. He is at the time of occurrence.
Postmortem report.
Now, if your lordships, it was quite a sensational case at that time. So what the
But you are not answering our question.
that age right.
She was a major, my lords.
That makes no sense.
The postmortem report will indicate the age.
Constable has to be major.
No,
The
the
minor
postmortem report will indicate the age.
We want the age of the lady. 23 years. PM report. Yes. Yes, she was 23-year-old.
Sir, let me say this across the bar that so far as the rape in the allegations in accused number 2, those materials are not good enough.
So far as accused number 1, you have got a good case.
Yes. Well, accused number 2, I can say as an officer of the court that the materials are not good enough. So far as accused number 1.
With due respect, my lords.
Let him complete. We will come back to you. We will not pass any order without hearing you. Yes.
I'm just trying to simplify this for you. So far as accused number 1, I have listed out the circumstances at that heading my note may kindly see. Of that convenience note I have given today. It's also available in the digitized form. The first one. The deceased.
Last scene.
Last scene is there. I'll just place that because these 4 points will clinch the case.
Okay.
Deceased and accused number 1, the last scene going to the quarter of accused number 1. Now the incident happened just beside the police station, inside the quarter of accused number 1.
It is an official quarter.
It is an official quarter.
At 5:05 p.m.
My lords. So they were seen together at about 1 p.m. and the death of the deceased was reported at about 5:05 p.m.
Who is PW29?
There are witnesses who saw the A1 going hurriedly from that quarter. So all those materials are there. So this is one first important circumstance. Next, my lords, would be serial number 2.
9 is a relation of the deceased.
Wait for me.
Please acknowledge that.
In charge.
That's what. He's a police officer under the Police Act itself.
Yes.
Even under Orissa Police Act, he is held to be an officer.
Yes.
Suppose if there is any phone call, we want to know any urgent call. Police officers cannot run in a road roller speed. They have to go speed only. Is it not? Whether in the station house diary, anything is recorded, warranting he's leaving the place immediately. And with that speed.
Nothing.
No evidence on that.
No. And next, my lord, is the most important thing, facet of this case. He absconded from the police station for 3 months. And this one circumstance is good enough. He was the officer in charge in the adjoining police station. He absconded.
What was the explanation offered for that?
Explanation is that he was scared.
He was scared.
Scared.
That is put to the prosecution witness. Anybody examined from the side of defense, or only prosecution witnesses were cross-examined, as it happens usually in this country?
Well, 46 prosecution witnesses were there.
To whom this suggestion was made?
Now, this direct material about his
I'm asking you. You said 3 months he was absconding.
Yes.
So no disciplinary inquiry, nothing of the side government?
That I don't cross. Regarding DP, I will have to cross-check.
That we have to see, na? Suppose if the government has deputed him for some work, we do not know. Therefore,
that material is not there. It's not that he has been. That is not the case of.
Understood. How? To which witness it is suggested that why he was absconding, etc. Which witness? Absconding is one of the great factors that goes with the that militates against the innocence of the accused. That's all right.
Other issue, other clinching factor would be that the weapon of offense was the service revolver of accused number 1. His own quarter, his service revolver. Dead body is found.
How death is by?
By gunshot injuries.
Gunshot injury to the temple.
Now, this is a clinching or another important facet. His weapon offense, this revolver is used. Dead body is found in the bedroom of the accused number 1's official court. adjoining the
Accused number 1 is not married? He was married. Where was his wife?
He was not inside. No, there was nobody inside.
Kind of prosecution. No, what is the explanation? If he is a married person, what is the explanation for the absence of the wife at home? It's a very which Kenny in outlines of criminal law suggest. If they are married in India, at least, the matrimonial home is the place where spouses reside.
Has not been gone.
In
fact, I can tell this that the prosecution, they have gone on rape, gang rape, whether the lady so they have gone on various issues which would weaken our case. But these clinching circumstances.
What ballistic evidence says? Weapon used.
Gunshot and the service revolver, everything has been marked.
Everything has been marked. That ballistic expert is examined?
Yes.
Examined as?
PW 46. And the ballistic report is at Exhibit 19.
How many years of service A1 had put in? But revolver was retrieved from the hand of the deceased.
Defense is taking a plea that it's a case of suicide.
No, ballistic report, does it suggest that it was not fired from the
firing range?
Firing range. Then you have a more difficult. I mean, then your theory would be that it was fired from the range of suicide, but still it was a homicide.
No, not like that. Once she shoots on the right, which side? Right side, right temple? Right temple it must be, unless she is a left-handy. Is it not? How the entire nervous system comes to a halt? If that is so, how is that the revolver will remain in her hand? How this matter is treated by the court below? What Modi's medico-legal jurisprudence says on that?
Those materials we have already given by way of Modi's book and all, we have given photographs. But
is that photograph of that lady that holding the pistol?
Photographs are also there on record. Lordship wants the NCR.
No, what Modi says, what Modi's medico-legal jurisprudence says, when one shoots to oneself at the temple, what would happen? How the nervous system breaks down? And how is that the pistol will remain in the hand of the deceased? On that, there are cases.
All those materials are all there. We have produced it before in Lordship Court in the digitized version. It is there from page 175 onwards in the PDF version.
Take us to the scene of crime sketch.
So, may I just quickly submit what we are trying to tell you about?
Last scene going to the quarter by PW 24, which is 29. Then at the time when the shot took place, immediately he left on his motorbike with high speed, and that was seen by other witnesses.
By PW 29 and 27.
Third is that he was away from the scene for a period of 3 months.
Yes. And he absconded.
Did he apply for leave? The cases and materials by Smith and Hogan. So beautifully, the English judges, they have treated this subject so beautifully. Just look into, we'll also look into. Yes, this requires the
look into those other parts that English also we have printed down every question of member come back.
And my brother asked that whether the fetus was sent for DNA test.
That also I know.
That you have to see. Very good.
May I submit one thing, Miller?
Yes.
Next matter 44.
Yes, sir.
So it's an old matter. Can I pray that let it come sometime after 1 week?
After 1 week?
It's a government appeal. I am for the respondents. Appeal against executed state is to argue. Not tomorrow, but some after 1 week or sometime if you lots of
very good, very good. This you are fixing for which date? This matter.
This matter, when do you want?
When do you want, Mr. Pandar?
Day after tomorrow.
No. We have to just we have to process. We have to read again.
Any date convenient to the court.
Okay. And the 10th of July? All right. Is it convenient?
10th of July, I will not be available. I have fixed the sessions on 9th and 10th. Thereafter, 11th or any other date.
Whichever date you say, we will put it.
11th of July is okay.
All right. 11th of July.
Lord, my matter may also come on 11th.
No, how? This matter itself will eat away most of the time. We will call it after, little after, thereafter.
Yes. No. Let me there. It will be a pleasure to hear the matter. We
will have that matter.
The way your lordship is going, if the matter is listed, then only we will be, while waiting, we will be hearing the case.
Very well, no issue. We will learn from you.
No. We have never heard mentioning those type of
matters.
English judgment in the more than 4 decades of practice, to be very frank, precisely.
Well, all right.